Many thanks. And we now move to the next item of business, which is a debate on motion number 7791 in the name of Margaret Mitchell on corroboration. I'd invite members who wish to speak in this debate to press the request to speak buttons now or as soon as possible. And I now call on Margaret Mitchell to speak to and move the motion. 10 minutes, please. We are extremely tight for time, so an exact 10 minutes, please.
Thank you very much, Presiding Officer. In support of his recommendation to abolish corroboration, Lord Carloway described it as an archaic rule that has no place in a modern legal system. This assertion has been repeated continuously on the airwaves today and is also contained in the Cabinet Secretary's amendment. It is a statement which, at the outset of this important debate, is worthy of further scrutiny, rather than just being automatically repeated without considering what it means. The Chamber's 20th century dictionary definition of archaic is ancient, savouring of the past, not absolutely obsolete but no longer in general use, and old-fashioned. Whilst the term ancient, even savouring of the past and old-fashioned, may well be correct descriptions to apply to corroboration, the remainder of the definition, the term archaic, is both inappropriate and quite simply inaccurate when applied to corroboration as a rule. For corroboration is, in practice, a principle which, far from being not absolutely obsolete, but no longer in general use, is currently, just as it has been for centuries, at the very heart of the Scottish criminal justice system, and one very much in general use on a daily basis, where it provides a safeguard against miscarriages of justice and all the misery that results from this, and for complainers and accused alike. Absolutely.
The member will also be aware that Lord Carloway said that his extensive research, he could find no other jurisdiction in Western Europe or indeed the Commonwealth who had corroboration. Is he wrong, or are all these other jurisdictions wrong?
The fact that no other jurisdiction has it is not sufficient reason to abolish it here. I find that a bizarre argument. So the use of the word archaic is not merely a point about semantics, but rather indicative of the superficial debate and arguments that have so far dominated the consideration of whether corroboration should be abolished. A debate which up till now has been focused on two polarised views, for and against abolition, with no consideration of a possible third and better way. Worse still has been the attempt to portray this as the vested interests of the legal profession against the rights of victims. This is a gross distortion of the issues at stake, as the views of and submissions from the cross-party group on adult survivors of childhood sexual abuse confirms. But sadly, it is one which, to a large extent, has been encouraged by Lord Carloway himself when he gave evidence to the Justice Committee yesterday and dismissed the views of key stakeholders in the criminal justice system in the form of representatives of the legal profession. These include High Court judges and senators of the College of Justice, the Law Society of Scotland, the Faculty of Advocates, who together with the Scottish Police Federation, the Scottish Human Rights Commission and significantly the Cross-Party Group on Adult Survivors, are all against abolition of corroboration. Very briefly.
Margaret MacDonald.
Would it be possible to find out whether or not everyone who speaks agrees with going to a new verdict, proven and not proven?
No doubt they'll make their position clear, but my own view is if corroboration was abolished, then it would strengthen the argument for a not proven verdict. All these views deserve to be heard and carefully considered. They include the fierce, passionate, yet well-reasoned and justified comments received by me from the local bar associations. For example, one of these respondents pointed out that there is an irony in the Scottish Government's proposal to remove corroboration on the basis that to retain it would be to support an archaic principle, when the self-same Scottish Government wishes to take Scotland back 300 years with its independence referendum. The same respondent went on to stress, without doubt, the removal of corroboration will be to the detriment of our much admired and ancient legal system. Another respondent made the following comment: I cannot express in terms sufficiently strong the great fear that my Parliament's proposal to remove the requirement for corroboration instills. As a society, I fear this moves us towards the Nazi doctrine, Better 1,000 innocent men are convicted than a guilty man should go free. Other comments included, I do not accept the argument that simply because it is a feature unique to our system, it, i.e. corroboration, has no place in modern times. I consider, as do all my colleagues, that the removal of corroboration is a solution arrived at in haste to address two issues in particular. An anticipated fall in the conviction rate brought about by a decline in confessions by legally advised accused, and the perceived need to increase the conviction rate in relation to crimes committed in private. There are many more equally valid comments, but the final one I want to highlight was this. I have no doubt that if corroboration is abolished, as proposed by the Scottish Government, it will lead to many more wrongful convictions. I understand the Scottish Government's concern for victims, but what they will do is create a whole new category of victims, i.e. those who have been wrongly convicted on the basis of one person's testimony.
I thank the member for giving way. One of the things which concerns me about all of this is that the Carloway Review itself looked at 141 sexual offence cases that were dropped between July and December 2010. It found that two-thirds, 95 of these cases, would have had a reasonable prospect of conviction without the requirement for corroboration. It is the sexual offences situation that really bothers me, and the fact that so many cases do not go to trial.
Margaret Mitchell.
Stand and sympathise with the member's point, and perhaps as I develop my argument, I can give them some comfort in this respect. I cannot express in terms, these comments represent a clear indication of the strength of feeling against the abolition of corroboration, which, as the motion stresses, cannot be looked at in isolation. At present, the requirement for corroboration must be considered at different points in the criminal justice system. For example, under solemn procedure, by the police investigating a crime, by the prosecutor's marking decision at trial, first by the prosecutor, then by the trial judge, by the jury deciding whether or not it accepts specific evidence, and finally at appeal. Furthermore, the fact that no other jurisdiction has the requirement for corroboration is not Cabinet Secretary in itself a reason to support its abolition. And again, the attempt to polarise the debate between those who want to modernise the criminal justice system and those opposed does not stack up. For despite the overwhelming view of the judiciary that corroboration should not be abolished, this is not the same as saying corroboration is not capable of improvement, modernisation and change for the better. Here, the cross-party group, I've been very generous, if you don't mind, I'll develop the argument. Here, the cross-party group on survivors of childhood sexual abuse suggests for improvement make some suggestions for improvement, which may address some of the concerns in the Labour amendment and expressed by Kevin Stewart this afternoon. These suggestions include wider definitions of corroboration be permitted in cases of rape, sexual assault, child sexual abuse and domestic violence, where there is regularly unlikely to be a witness while still maintaining fairness to the accused. Further consideration of the introduction of more circumstantial evidence to help support corroboration in a chain of events. More systematic and constructive use of expert witnesses. Reviewing the application of the time period element of the Moore Doctrine, which has offered the opportunity for justice for victims of crimes of interpersonal violent crimes, where the modus operandi is similar, leading to more flexible marking of cases by fiscals. The group make many more evidential suggestions which I could and believe would result in an improvement in the application of corroboration. Yet Lord Carloway failed to consider the option for the retention of corroboration within the context of looking at the law of evidence to improve its application, despite it being competent to do so under the review terms of reference. And it is this failure that renders his review fundamentally flawed in terms of corroboration. The motion seeks therefore therefore to ensure that this option, together with the options to either abolish or retain corroboration, are properly discussed in an open and transparent manner, being subject to the widest independent review. A wider review of the law of evidence should be carried out, including the interaction between corroboration and laws of evidence, either by referral to the Scottish Law Commission or a public inquiry. And here it's important to note that the term public inquiry has a very broad meaning, and there are a number of forms of inquiry available. The type of public inquiry suggested here would be similar to the commission established under Lord Thomson in 1970, which carried out a wide-range examination of Scottish criminal procedure and produced 3 reports referred to in the 1220 paper by Professor Chalmers and Dr. Leverick. In this paper, the authors warned that never before have sweeping changes to the Scottish criminal system been as a result of a single individual, and that the Carloway Review was a model of criminal law reform without recent precedent. In conclusion, Presiding Officer, it's totally unacceptable that a decision of this magnitude is crammed in with the Justice Committee's scrutiny of the Criminal Scotland Bill with its miscellaneous provisions. I move the motion in my name.
Many thanks. Now call on Cabinet Secretary Kenny McCaskill to speak to and move Amendment 7791.3. Cabinet Secretary, 7 minutes, please. And would you like to orientate your microphone?
Thank you, Deputy Presiding Officer. I welcome the opportunity to respond to this motion on the proposal to abolish the general requirement for corroboration in criminal cases. This is a long overdue step in ensuring victims have access to justice. The Criminal Justice Scotland Bill seeks to modernise and improve efficiency in our system and put Scotland at the forefront of human rights protections for suspects, whilst ensuring victims are not denied justice by outdated rules of evidence. I think it's important to acknowledge that we're all working towards the same goal. We want Scotland to have a modern and effective criminal justice system, one fit for purpose in our modern age, and which properly balances the rights of individuals and the duties of the state. That is why I asked the Lord President to nominate an expert to undertake an independent review of criminal law and practice in the immediate aftermath of Cadder and the subsequent emergency legislation. Lord Carloway rigorously reviewed the key elements of our system. He spent a year consulting and deliberating, and he focused his recommendations on how we could best combine thorough investigation and prosecution of crime with rigorous and far-sighted human rights protections. The Government then conducted a general consultation on his report and a second consultation on possible additional safeguards following abolition. The provision in the bill to increase the jury majority for a conviction to 2/3 is a direct result of consultation, and I've also agreed in principle with the Scottish Law Commission to review the not proven verdict, and I remain open to deliberating whether further safeguards are needed as the bill progresses. By all means.
That the Commission for Human Rights is against abolition, and does he have any concern that the testimony of one witness could lead to a miscarriage of justice and a challenge under Article 6 of the Human Rights Convention, i.e. the right to a fair trial?
Cabinet Secretary.
Well, yes, I would have concerns if it was simply be the testimony of one witness, but we have clear guidance being given by the Lord Advocate that that will not be the test, and that is simply not going to happen. There will have to be additional evidence, which is why Lord Carloway made it clear it was not quantity but quality of evidence. So that is the position. Not at the moment. I remain in complete agreement with the damning conclusion reached by Lord Carloway. He said, and I quote, "The requirement of corroboration should be entirely abolished for all categories of crime. It is an archaic rule that has no place in a modern legal system." By all means.
Graham Pearson.
Thank you very much for accepting the intervention. The Cabinet Secretary would acknowledge that the Senators for the College of Justice are somewhat different in their views and recommendations, and to accept the recommendation of solely Lord Carloway is a dangerous way forward.
Secretary.
The views simply and solely of Lord Carloway, but their matters have been contributed by Police Scotland, by the Crown, by Victim Support Scotland, Scottish Women's Aid, Rape Crisis Scotland. These matters are debated and discussed by us as a national parliament, Not one profession has a right of veto or the prerogative of deciding simply what happens with regard to law reform. It's a matter of a democratically elected chamber, and we require to, not at the moment. The law on corroboration has been debated for the last 3 years. At no point has anyone identified another system operating a general rule for corroboration. Indeed, we can positively rule out all of the most directly comparable jurisdictions, in particular common law systems, and all 47 signatories of the European Convention on Human Rights. The requirement is regularly invoked as guarding against miscarriages of justice, but Lord Carloway could find no evidence to suggest it does anything of the sort. Instead, he found evidence the other way, specifically that it stops our court from hearing cases that would be tried elsewhere. And I can remind the Chamber of the point and intervention made by Kevin Stewart about the cases. In 95 of those cases, 67% would have had a reasonable prospect of conviction without the corroboration test. Put simply, the requirement for corroboration has failed Scotland. It was formulated in a different age, before even matters such as DNA or CCTV. Times have changed. What Lord Carloway was asked to do was a root and branch review. It was logical and thorough, from first suspicion to final appeal. Corroboration in our legal system is a barrier to obtaining justice for the victims of crimes committed in private or where no one else was there. Abolition is not and can never be a panacea for resolving the well-known problems in addressing sexual crime. But at the very I'm running short of time. At the very least, abolition of the requirement for it will allow crimes committed in private, where the complainer has suffered in silence or behind closed doors, to be brought to court. That can only be a step forward. And I must stress that the bill seeks to remove the general requirement for corroboration, not the concept of corroboration. Police and prosecutors will continue to seek the best evidence available, and corroborative evidence will remain important. And I welcome the recent publication by the Crown of its new prosecutorial test to be used following abolition. The test is two-pronged. Firstly, an evidential test looking at the quantity and quality of the evidence, including an assessment of admissibility, credibility and reliability, and secondly, a public interest test, one that is rigorous and no doubt will be considered by the Justice Committee. Removing the requirement will mean that cases are assessed on the overall quality of evidence. The burden of proof will remain. Each case will require to meet the high standard of proven beyond reasonable doubt. The jury majority will be raised to a two-thirds majority for conviction, a position supported by the senators of the College of Justice, and I am open, as I said earlier, to hearing further suggestions on additional safeguards. Having identified this barrier for vulnerable victims in accessing justice, we must now act. We must abolish the requirement for corroboration. In a modern society, it is simply not acceptable for victims to be left to suffer in silence and for justice not to be delivered. I remain open to constructive debate on how best to achieve this reform and on any additional safeguards, and will clearly be looking with interest at the work of the Justice Committee. But to conclude, Deputy Presiding Officer, I move the amendment in my name.
Many thanks. And I now call on Dr Elaine Murray to speak to and move Amendment 7791.2 in the name of Graeme Pearson. 5 minutes, please, Dr Murray.
Thank you, Presiding Officer. One of the most important functions of the committees of this Parliament is to scrutinise legislation proposed by the Scottish Government. And that is a role which is particularly important because of the unicameral nature of the Parliament. It is therefore, I believe, not appropriate that Parliament should determine its position on a very controversial element of a government bill prior to stage 1 consideration of that bill. This is a proposal contained in a bill which is currently before Parliament. And the issue concerns whether the innocent are unjustly convicted or indeed whether the guilty go free. And therefore the evidence for this change must be carefully and rigorously examined. And I don't think this is an issue which Parliament should make a decision on based on less than an hour and a half's debate in Parliament. This committee will take evidence at 2 sessions in November and December, and it is at the end of stage 1 that the decision ought to be taken. Very briefly.
Margaret Mitchell.
Isn't that an argument for taking corroboration out of it, having that full debate now, that wide independent debate?
Dr Murray.
No, I don't think it is, because there have been many controversial clauses in government bills over the years, and they go through the committee process, and we examine them. That is part of our job, to examine those processes and to make recommendations at stage 1. It is actually the case that 12 organisations, many of them, of course, representing the victims of crime, support the government's proposals on the abolition of corroboration, and 15 express degrees of concern, ranging from outright opposition in some cases to the need for additional safeguards or a wider definition, indeed, of what constitutes corroborative evidence. Many of the organisations which support abolition believe that this would assist, of course, in the prosecution of crimes such as sexual offences or domestic abuse, where corroborating evidence can be difficult to produce. Corroboration, of course, it requires that there must be a source of independence of evidence independent of the primary accusation that a crime has been committed and the accused has committed it. And removal of the requirement, sorry, I've only got 5 minutes, removal of the requirement for corroboration theoretically permits cases to go to court on the evidence of one witness or victim, but there are other safeguards which can be put in place. Mr Stewart referred to the 6-month period in 2010 when 2/3 of sexual offence cases, some 95 cases, and that is a matter for concern, some 95 cases were dropped, which could have been reasonably prosecuted had corroborating evidence been required. But of course, this does not mean that they would have been successfully prosecuted in proving guilt beyond reasonable doubt. But no, sorry, I've only got 5 minutes and I'm halfway through. But supporters of abolition argue that proving guilt would then be dependent on the quality of the evidence rather than the quantity of the evidence. And that indeed is the view of Police Scotland, for example, who actually say in their evidence that the requirement for corroboration of every material fact is an anachronism. However, there are some very potent arguments on the side of retention of corroboration. The Law Society, Faculty of Advocates and Justice Scotland argue that corroboration is a fundamental principle of the Scottish criminal justice system, and that the proposed 2/3 majority verdict is an insufficient safeguard against possible wrongful conviction on the evidence of a plausible and convincing liar. The Scottish Government, of course, did consult subsequently on other safeguards, such as giving judges the power to acquit the accused without reference to the jury if it is considered that no reasonable jury could convict, and also approving the 3rd verdict. And I think it's important that that is actually considered, and I welcome the fact that the Cabinet Secretary has indicated that that is prepared to be considered, because, as colleagues will know, Michael McMahon, MSP, has actually proposed introducing a Members' Bill to this effect and could be considered at the same time. Abolition of corroboration could have other consequences. Also, the Scottish Police Federation and the Law Society fear that there could be more malicious prosecutions of police officers and of people who work in one-to-one situations, such as social workers and prison officers, if corroboration is removed. The Police Federation and Justice Scotland argue that the conviction rates in England, where there is no corroboration, are very little different to those in Scotland. So there's actually no evidence that removing corroboration will actually result in more successful prosecutions. And organisations representing victims of crimes such as sexual violence, while welcoming abolition and opposing, as it happens, the increase in the majority verdict, also argue that the education of juries and a fundamental change in attitude is central to the successful prosecution of domestic and sexual crimes, and to encouraging victims to come forward. So it's not as simple as taking away the corroboration. That will not be sufficient to solve the entire problem. But to conclude, we believe that the committee must give due consideration to the arguments on both sides and the necessity or otherwise of additional safeguards should abolition be agreed to. And also, indeed, whether or not the corroboration, the definition of corroboration, as Margaret Mitchell's implied, could actually be widened in order to take account of some of the issues. But Parliament should not make this decision today, and therefore I move the amendment in the name of my colleague Graham Pearson.
Many thanks. We now move to open debate. We're extraordinarily tight for time. Calling Sandra White to be followed by John Pentland. Up to 4 minutes, please.
Thank you very much, Presiding Officer. I'll try and be as quick as possible. I just want to note to Margaret Mitchell, when she mentioned about the fact that we shouldn't be looking at corroboration within the Criminal Justice Bill. I know you've just become a member of the Justice Committee, Margaret, but if you go to page 5 of the recent minutes, it mentions here the committee noted an underlying consensus that corroboration rule should not be seen as sacrosanct, and it was legitimate to reinvestigate from first principles whether it continues to serve a useful purpose in 25 21st century criminal law. The committee agrees. And that's, I think you should actually look at that particular part of it, Margaret. I'm sorry I've not even got 4 minutes. I'm very sorry about that. I also wanted to go back to what I would probably call the basics, because yesterday in committee, and I must say, I think the behaviour of some of the committee members raises some questions in regards to them, and not so much perhaps in regards to the witnesses. But in yesterday's committee, I did ask Lord Carloway about corroboration, and his reply was, corroboration is not widely understood by the public, by the courts and by the judiciary. And my answer to Lord Carloway was that I'm not a member of the judiciary, I'm not a member of the legal faculty, but I do represent constituents, and I think that we should be looking at the whole, the corroboration issue in a holistic approach rather than just individually, because it is part and parcel of a bill. And I think it's interesting to see Lord Carloway's reply that yes, the judiciary and even the public don't quite understand what it's about. And I think this is where Margaret Mitchell's motion has got a little bit lost. It is putting the cart before the horse. Now, I really, Elaine Murray's contribution, I thought was very fair, it was excellent, and it did mention the fact that here we are on a committee, we're at stage 1 of a committee, debating all of these factors, and yet we have it here before us in a motion in a very, very short time. I think if it's so important, it should have more time than that, and I look forward. I'm sorry, no, I actually look forward to hearing witnesses. We'll hear from the Cabinet Secretary, the Lord Advocate, various other groups as well. Surely they're the people that will give us the evidence to make up our minds on what we think of corroboration. And I would also perhaps turn Margaret Mitchell's attention to the actual bill and the explanation of corroboration, which is on page 25. Corroboration not required. It says, if satisfied that a fact has been established by evidence in the proceedings, the judge, or as in the case may be, the jury, is entitled to find the fact proved by the evidence, although the evidence is not corroborated. So that's what it says in the bill. We also had not just Lord Carloway's evidence, but also the Cabinet Secretary's contribution, which actually gives an explanation of corroboration. Corroboration is not going to be done away with. And that's the frightening part of what Margaret Mitchell's actual motion said. You're actually frightening people out there. Corroboration and actually the quality of evidence is more important. Well, I'll read that paragraph out to you. The bill seeks to remove the general requirement for corroboration, not the concept of corroboration. And I really think Margaret Mitchell should be looking at that. We have people out there, and I know that some of my colleagues are going to talk about the very sexual and violent crimes which are behind closed doors. But the fact of the matter is there are other people who are affected by this, and we had evidence in the papers from a sheriff who mentioned older people, children in care, the things that go on behind closed doors there. They're entitled to get evidence as well. They're entitled to basically be able to have a witness. Please. And it's not just certain crimes, it's crimes all over. And I think that we, as members of this committee and this Parliament, have a right to stick up for the victims of crime as well. Thank you, Presiding Officer. Thank you.
Now call on John Pentland to be followed by Christine Graham.
Presiding Officer, as a member of the Justice Committee, I will be looking at the issue of corroboration over the coming weeks. As we have heard earlier, the battle lines for and against have been drawn, but I don't want to preempt the evidence that people will give to the committee. Now, I appreciate there are compelling arguments on both sides. In many ways, corroboration has served us well. It is a deep-seated part of our legal tradition that helps to avoid false convictions, and examples of miscarriages of justice are few and far between. The counter-argument, however, is that the guilty may escape prosecution. Corroboration is frequently an obstacle to conviction for rape and attempted rape. Strong evidence can be rendered unusable, and significantly, we are unique among the developed countries in requiring corroboration. Now, I know the supporters of corroboration argue that Scotland has a higher conviction rate for rape and attempted rape cases than England. However, I also know that statistics are rarely as straightforward as those who quote them and would like us to believe. The conviction rate tells us how many prosecutions were successful. It does not tell us how many reported cases were not prosecuted, and we can only guess how many cases were not reported and whether lack of corroboration was a factor in this. Corroboration will remain an intrinsic part of our legal system and should not be abandoned where it is really readily available. For example, post-mortem pathology and related forensic examinations should continue to be subject of two-person reports. Corroboration is at the heart of the checks and balances that, on one hand, seek to minimise false convictions and, on the other, seek to ensure the guilty do not escape justice. So any decision to reduce the need for corroboration would also need to ensure that safeguards are put in place to maintain and strengthen those checks and balances. Those checks and balances include the verdicts that can be returned and the number of jurors needed to deliver a verdict. The SNP say that requiring 10 jurors rather than 8 out of 15 will be an adequate safeguard. But other countries, where there is no corroboration, require more than 2/3 of the majority verdict, and some require unanimity, and would be changing the basis of our legal system without considering the not proven verdict. So is corroboration an integral and essential part of our centuries-old law? If it is, and it's not broke, why fix it? Or is corroboration a barrier to prosecution, merely as an archaic aspect of our legal system? Maybe's aye, maybe's no. Maybe's we should listen to the evidence and look at what safeguards are on offer and carefully consider their adequacy. And if we do abandon corroboration because it's the right thing to do, we also need to consider the implications for police and courts faced with shrinking budgets and expanding workloads. There are a lot of questions still needing answered, so let's not make up our minds before we have heard all the evidence and look at the issues properly.
Many thanks. Now call on Christine Graham to be followed by Alison McInnes.
Thank you, Deputy Presiding Officer. First of all, let me agree with Sandra White by saying the requirement for corroboration is not sacrosanct and debate is welcome. Secondly, I would ask members to have regard to the rigorous and robust interrogation of the arguments for and against its abolition or retention, a rigour, and it was rigour, I don't think bad manners, that will be applied to all giving evidence in the coming months to the Justice Committee and, of course, our Stage 1 report. Members, with respect, may make their own inquiries, but only those in the Justice Committee or those following it, blow by blow and hourly blow, in my view, will have fully scrutinised all aspects of the case for and against. Thirdly, while I appreciate the popular view that abolition of mandatory corroboration will bring the prospect of greater justice to those victims of, say, sexual abuse, rape and so on, if passed, it will apply to all criminal cases, where there is not a statutory penalty in both the Sheriff and High Courts. And I hardly need to say corroboration does not mean two witnesses. Indeed, corroboration can come from the same source. An alleged rape victim, her corroboration or his corroboration can come from their demeanour, emotional or psychological. So it's a very broad, and I do understand the law of corroboration. Turning now to the Conservative motion, I agree with the list of those who oppose abolition is correct, just as the Labour amendment and the Government amendment are correct in naming the support for. But that doesn't take us forward in determining whether this is a good or bad proposal. Police Scotland, the Chief Constable favours, the Police Federation does not, for example. It is the evidence they produce which has to be tested. It's not a case of my list is better than your list. What that demonstrates is that this is complex and contentious, and rightly so. However, I do think that the Conservative amendment is correct to indicate that corroboration cannot and should not be examined and evaluated in isolation. That is the matter of jury size and majority, the 3 verdicts available in Scotland, the abolition of the double jeopardy rule, the restrictions now placed on the SCCRC and referrals to the High Court. I am sympathetic to that wider review, in particular giving a role to the Scottish Law Commission, which has the disinterested expertise to examine all these interlocking issues. However, the call for a public inquiry is inappropriate. The Government amendment also presents a difficulty for me, and again in parts I cannot accept the quote that the Carloway review and corroboration was, quote, thorough. Firstly, it is Lord Carloway's proposal alone. Secondly, it was not thorough, and I would refer you to the evidence yesterday in relation to the criminal cases he asked to be reviewed to determine whether, without corroboration, these would have been prosecuted, and secondly, have obtained a guilty verdict. Of that sample of 141 sexual cases in 2010, it was concluded that 67% would have been successfully prosecuted. Who came to that view? 2 prosecutors, 1 active, 1 retired. That's it. Now, forgive me, I cannot say that that is a rigorous examination of evidence. Finally, I'll return to where I started with the role of the committee. The Labour amendment doesn't move matters forward. I'm abstaining. It's superfluous. For reasons I've said about the Conservative motion, I'm also abstaining, and I'm also abstaining on the government's amendment. But I want to say this to the Chamber. We are here both as politicians and legislators. Let's not consider the proposal to abolish corroboration with our politicians' hat on. Let's behave like responsible legislators. What Scotland needs, whatever the outcome of the bill at stage 3, should be because it improves justice for complainer and accused, not because it's politically popular.
Many thanks. Now call on Alison McInnes to be followed by Roderick Campbell. Up to 4 minutes, please.
Thank you, Deputy Presiding Officer. Since the foundations of Scots law were laid, it has been established that no individual should be convicted of a crime based on the testimony of a single witness. But I don't defend corroboration because of tradition. I defend it because it protects against miscarriages of justice, false accusations, wrongful convictions, and the erosion, I believe, of the presumption of innocence. And the fact is, you cannot remove this pillar of our justice system without making the whole structure unstable. In other jurisdictions, in the absence of a corroboration rule, there are a whole series of alternative checks and balances built into the trial process. For example, in England, Wales and Northern Ireland, they have greater regulation of police investigations, preliminary hearings to test the quality of evidence. Judges have the power to exclude poor quality or prejudicial evidence. Unanimous verdicts are required in the first instance, and there are wider grounds of appeal following an unsafe conviction. The additional safeguards currently proposed are, in comparison, utterly inadequate. The draft bill will mean that someone could be convicted on the basis of the testimony of one person, even if 5 of the 15 jurors believe they are innocent. You know, witnesses can be honest yet mistaken. And of course, unfortunately, witnesses do sometimes lie to the police and in court, out of earnest to ensure the accused is convicted, because of the strength of their convictions or through spite. Furthermore, scrapping corroboration could mean that false accusations could become more common. The Law Society of Scotland warns that trials could be reduced to a contest between 2 competing statements on oath. We cannot allow trials to hinge on lesser evidence. Now, I accept we must strive to ensure that the victims of rape, sexual assault and domestic abuse get justice, and Liberal Democrats wholeheartedly share the Scottish Government's aspiration to improve conviction rates in this area. However, sadly, rape conviction levels are not very high in any other jurisdiction either. It would take significantly more changes to attitudes that are deep and complex across society. But the research that the Government cite in support of scrapping corroboration to this end is scant. A simple desktop study, as a convener of the Justice Committee referred to, carried out by the Crown Office. In the absence of clear, in-depth evidence, it would be reckless to proceed in blind hope. There is also a real risk that scrapping corroboration could actually reduce the chances of victims of these crimes securing justice. Police investigations may become less rigorous. And even if we do get more cases into court, there is no evidence that we should secure any more convictions. The alleged victim could face a much more aggressive cross-examination. Juries are less likely to convict on the basis of one piece of evidence. So more acquittals or not proven verdicts in these cases doesn't help anyone. No one should be beyond the reach of our justice system, and we should therefore examine other ways of tackling this problem.
Final minute.
Should rape victims, for example, be represented by a lawyer in the court, something that happens in Belgium? Should we adopt a much more rigorous approach to the gathering of forensic evidence? The majority of Lord Carloway's recommendations are sound and should be implemented, but I'm really concerned that incorporating this profound change into the wider package of court reforms will mean that it is not given the due consideration it deserves, and I support Margaret Mitchell's motion today. Corroboration should not be seen as a barrier to justice, a cumbersome requirement that blocks cases being taken to trial. It does not simply deliver a quantity of evidence, it ensures the quality of it. It is the key to determining the guilt or otherwise of the accused. In Scotland, the Crown prosecutes in the public interest. We must guard against any shift towards prosecuting in the victim's interest alone. We should not cut corners in the pursuit of convictions.
Thank you very much. Now call Roderick Campbell to be followed by John Lamont.
Thank you, Presiding Officer. May I begin by referring to my register of interest as member of the Faculty of Advocates. It's clear that Lord Carlaway's proposal with regard to the abolition of the requirement for corroboration remains controversial. We certainly have no consensus on the issue. As Margaret Mitchell has indicated, a substantial part of the legal establishment remain opposed to abolition. There are, of course, many organisations and individuals who support Lord Carlaway's proposal, particularly those who regard corroboration as a barrier to conviction in cases where corroborating evidence is not always available, such as rape or sexual abuse cases. With this fundamental divergence in views, it's unlikely that consensus will ever be found. Perhaps I might draw the Chamber's attention, however, to an anonymous contribution to the Scottish Government consultation on additional safeguards. I quote, "But it's ultimately for juries to decide whether they are prepared to convict on the basis of good quality relevant evidence, albeit from a single source. We already allow them to convict on the basis of poor quality evidence of dubious relevance, but we justify it to ourselves because it comes from two sources. This is a pre-scientific, irrational way of guaranteeing fair trials. The government must make its case more vigorously and must not allow the media lines to be dominated by the narrative imposed by the reactionary institutions of the Scottish legal profession, who have, let us never forget, uniformly opposed every sensible and necessary reform of the last 500 years, from moving divorces to the Sheriff Court, the introduction of the Criminal Appeal Court, and even the establishment of the College of Justice itself. While as a practising advocate I would not necessarily accept that, I think it's fair to say that the legal profession is not always on the side of the angels. Where I do agree with others, however, is in not being overwhelmed by the research in the Carlaway Review, to which Christine Graham has referred, on the impact of abolition. I am clear that the abolition of corroboration may have little impact on conviction rates for sexual assault and rape cases. As to the number of prosecutions, I think the position is not clear-cut. However, with a new prosecutorial test embracing both a quantitative assessment and a qualitative assessment before an assessment based on the evidence of the question of whether there is a reasonable prospect of conviction, as Lord Carlaway agreed yesterday, it's not necessarily the case that there will be more prosecutions. What's clear, however, is that cases which are currently not pursued will be, and that some cases which currently are pursued will not be. That in itself, I would suggest, may have a positive impact on reducing miscarriage of justice. As Lord Carlaway says, inability to pursue a case at all because of the requirement of corroboration may itself be a miscarriage of justice. In the absence of consensus, however, I think it's incumbent on this Parliament to look very closely indeed at the question of safeguards. I was pleased that the Scottish Government took this on board and launched a second consultation on the additional safeguards required if the requirement for corroboration were abolished, and did not simply accept the view of Lord Carlaway that no additional safeguards were required. I was rather less pleased, however, by the response to that consultation, particularly in relation to the question of whether a single judge should have the power to withdraw a case where he is of the view that no reasonable jury could convict the accused on the basis of the evidence led.
Final minute.
The policy memorandum in paragraph 182, I suggest, fails to critically consider the matter. However, on the question of the Scottish Law Commission, it's a reasonable assumption if they were asked to look at that particular issue, they would take the view that they took in 2008, that a single judge should have that power. That perhaps illustrates that referring matters to the Scottish Law Commission will not by itself advance matters and is no silver bullet. But to end on a more positive note, it's precisely the area of safeguards which need further scrutiny, and both the Government Amendment and indeed the Labour Amendment recognise the role of the Justice Committee. That, I believe, is the proper way forward. We need to also ensure that we fully explore the extent to which abolition might raise Article 6 issues. The lesson of Cadam being surely that we need to be ever mindful of fair trial issues. I think that's a more constructive approach than is proposed by the Conservative amendment, which I hope the Chamber will reject. Thank you, Presiding Officer.
Many thanks. I now call John Lamont.
Thank you, Deputy Presiding Officer. I welcome the opportunity today to defend a principle which has been described as the cornerstone of the Scottish criminal justice system. The abolition of corroboration should not be taken lightly, and it is the view of the Scottish Conservatives that, bluntly, Lord Carlaway has got it wrong, and the Scottish Government is mistaken to have accepted the recommendation to remove corroboration from our criminal justice system. Corroboration has an important place in our criminal justice system because it acts as a safeguard to miscarriages of justice in itself, but also because it effectively balances out the intricacies of the rest of the Scottish criminal law. By defending corroboration, lawyers, rank-and-file police, organisations like the Scottish Human Rights Commission are not standing up for the guilty, they are standing up for the innocent. Corroboration protects individuals from being convicted on the basis of a single witness and therefore acts as an important safeguard against miscarriages of justice. But equally as important, Deputy Presiding Officer, corroboration provides a safeguard for victims and witnesses. Were corroboration removed, there would have to be a far greater scrutiny of the quality of witness evidence before prosecutions would proceed and before courts would convict. Deputy Presiding Officer, the Scottish Government argues that corroboration has acted as a barrier to justice. However, the truth is that it has never been easier to prosecute. Corroboration has become a more flexible concept in Scots law, particularly in light of the Murov Doctrine, the relaxation of the rule against double jeopardy and the introduction of statutory exemptions. Admittedly, corroboration is now a complex rule, but that may be a reason for reform. It is not a reason for its abolition. So because the law has adapted, the requirement for corroboration is very much less onerous than it used to be. Furthermore, because of modern developments in evidence gathering, such as DNA identification, forensic analysis and the use of CCTV, from an available evidence perspective, there is less reason now to abolish corroboration than there ever has been. To put it another way, it is easier for the Crown to secure corroborated evidence than it ever has been before. Finally, Presiding Officer, the primary argument for this change is that the removal of corroboration will increase convictions, particularly for rape and sexual offences, which often lack witnesses. Poor conviction rates are extremely worrying, but abolishing corroboration is not the way to address this problem, nor will the removal of corroboration lead to increased convictions. The Scottish Government will no doubt and have pointed to analysis carried out by the Carloway Review, which concluded that from cases marked as unable to proceed due to insufficient evidence, 80% would have been able to proceed without the corroboration requirement, with 59% having a reasonable prospect of conviction. But this analysis was carried out by prosecutors who have no experience of a world without corroboration and who are then asked to essentially guess how many convictions would occur if corroboration was no longer necessary, and then second-guess the conclusion of juries. What is more likely to happen is that juries will be much more cautious to convict of the more serious charges without the corroborated evidence being available. Deputy Presiding Officer, the supporters of the abolition of corroboration are ignoring one simple fact. Any system of justice is essentially a human system, and no human system will ever be perfect. The major hurdle facing the pursuit of justice is the reality that people do not always come to court to tell the truth, and others, however well-meaning, fail to tell the truth. For centuries now, Scots law has accepted that sometimes a single witness can be reliable, and that by refusing to believe him or her, we may well be letting guilty people walk free. But that is a price worth paying because, on the whole, maintaining the requirement for corroboration will lead to less injustice than allowing convictions on the basis of a single witness.
I'm afraid you must finish.
I have great pleasure in supporting Margaret Mitchell's motion.
Many thanks. I now call Christina McKelvey to be followed by Anne McTaggart.
Thank you very much, Presiding Officer. As you know, as co-convener of the cross-party group on men's violence against women and children, I've seen a great deal of evidence from agencies and individuals seeking to support victims of domestic violence. And it does send a shiver of terror down my spine to think that 1 in 5 women are victims of domestic violence. Almost 30,000 domestic abuse offences took place between 2011 and 2012. That includes 307 attempted murders, 12 homicides, plus 485 sexual offences, and domestic common assaults made up 14,154 of that total. Presiding Officer, I would suggest that we are being naive if we refuse to recognise this reality. Just as misogyny and the sheer dismissal of women at work and at home continues to be a reality, so there remains a section of the stakeholders who do not welcome changes to the law. Corroboration is clearly virtually impossible for a woman who is brutally attacked in her home by her partner. She may be raped, battered and humiliated, but how does she prove it when she has to have 2 independent witnesses to uphold her complaint? Violent and abusive partners do not normally carry out their crimes in the views of others. with the possible exception of their children who may be very young and who will in any event be unable to provide disinterested evidence to a court. Lord Carloway has not suggested that corroboration is abolished, and neither does this bill. Police and prosecutors will seek the best evidence available and rightly will trust judges and juries to weigh the evidence put before them. Lord Carloway could not find no other criminal justice system operating a general requirement for corroboration, and there is no evidence to suggest it prevents a miscarriage of justice. For the victims of abuse, the corroboration requirement inevitably results in fewer genuine complaints reaching the courts. That is not good for our Scottish criminal justice system, which is so clearly discriminating against women who are usually the victims of domestic and sexual violence in following the current codes. Scottish Women's Aid has pointed out in its submission to the Justice Committee that where domestic abuse cases do not go forward due to technicalities, the removal of corroboration requirement would allow them to more readily seek redress through the courts. This, they add, would help to redress the balance where there are all the hallmarks of exposure to prolonged domestic abuse, only to be told that there is no corroboration. More widely, this change would reflect a growing awareness that many cases of domestic violence go unheard as a result of the current restrictions. That is fundamentally unfair to the victims of such abuse. Rape Crisis Scotland has also welcomed the move to change the requirement for corroboration and stresses that its existence diminishes a woman's right to redress. There are already excellent safeguards within the legal system to ensure that malicious claims would not proceed, not least the fact that they need to prove beyond a reasonable doubt that there is indeed a case to be answered.
Final minute.
The removal of corroboration requirement will probably require further safeguards to be imposed to ensure that no wrongful convictions can take place. And it is worth remembering, however, that miscarriages of justice can go in both directions, not only where a suspect is found guilty incorrectly, but where a guilty suspect goes free. There are concerns about whether the bill should allow the changes to apply retrospectively, and there are reservations about those changes to a jury majority and a guilty verdict. I take all of that on board. At the core of this debate is access to justice. In Scotland, we have historically always believed in and supported the right of every individual to seek redress from the courts. Do we want to deny that basic human right to that abused woman? I think not. We are not seeking to abandon the need for high-quality evidence. What we are seeking to do, as Victim Support Scotland has described it, is take a step towards a system that takes account of all fairly obtained evidence, respecting not only the accused but also the victims and their families. The law as it stands now is not fit for purpose in a modern Scottish system, and I support the Cabinet Secretary's amendment.
Thank you. And I now call Anne McTaggart.
Thank you, Presiding Officer. Corroboration is not only an important, unique feature of Scots criminal law, it's the cornerstone of Scots law. The University of Strathclyde School of Law professors John Blackie and Donald Nicholson have recently produced a research paper which studies the likely consequences of this profound change to the application of the criminal justice in Scotland. They state that whether or not the corroboration requirement is archaic or rather a reflection of ancient wisdom depends on whether its rationale remains persuasive in the context of the values, rules and practices of the contemporary Scottish criminal justice system and society more generally. Furthermore, within a criminal justice setting, it is clear that a core justification for the corroboration requirement is the perceived unreliability of witnesses. All forms of unreliable evidence are equally capable of causing wrongful acquittals as wrongful convictions. Arguments which have been utilised, for example, by members of the judiciary, certain academics and legal practitioners, organisations, some police organisations and the Scottish Human Rights Commission. Presiding Officer, secondly, I would like now to turn my attention to the reasoning for abolition. Lord Carloway and the Scottish Government did not question the historical rationale for the corroboration requirement. Rather, their argument had three main points. One, the requirement is not fit for purpose in being incomprehensible, inconsistent and ineffective. Secondly, it is disproportionately prejudicial to the interests of victims and the public. And thirdly, it is unnecessary because fact-finders can be trusted to evaluate accurately the strength and reliability of evidence free from legal regulation, and because there exists a range of other protections against unjust convictions. These points have been welcomed and used by government lawyers and some police organisations that have been joined by women's groups, as mentioned earlier, in their campaign for change. The points which I have highlighted, both for retention and abolition of corroboration in Scottish criminal law cases, are but the tip of the iceberg, and if anything, show the requirement and necessity for a referral to the Scottish Law Commission or a public inquiry. In conclusion, Presiding Officer, the false distinction between corroboration as archaic or an invaluable safeguard is a false debate. It is my view that we must focus on the tangible evidence from victims of crime, their support groups and the experience of our legal professionals across the country.
Final minute.
As a consequence, this proposal to abolish corroboration cannot be looked at in isolation and must be considered in the context of wider reforms to the criminal justice system in Scotland. Thank you.
Many thanks. And we now turn to the winding up speeches. We have no time at all in hand, and I call on Graham Pearson. 4 minutes, please.
Presiding Officer, thanks very much for giving me the opportunity to wind up in this debate. It's quite evident from the views expressed around the chamber that there is an element of discomfort in considering whether or not the proposal to abolish the requirement for corroboration is one that is to be welcomed or challenged. Indeed, we should bear in mind that Lord Carloway's job was not to report specifically in relation to corroboration. He reported on much wider elements in terms of criminal justice, and his comments on the requirement or otherwise of corroboration was one that he included on his own account and was not supported by the balance of the committee who dealt with his inquiry. Indeed, the Senators of the College of Justice have equally expressed their reservations about the way forward, and the convener of Justice Committee has gone some way to express her own views through the experience that she has convening that committee. I think that from my own point of view, we should take one set of guidance from Lord Carloway. It is important that when we decide the facts of this matter, we should weigh up the quality of the evidence that's provided to us by the discussions at Justice Committee and not merely weigh the names who are in support or otherwise of these proposals. Scottish Labour is no group who are distant from reform. We've led reform for many decades, and there's no doubt that the courts and legal process does need reform. My worry is that what we have in this proposal is merely a fiddling of one part of the system and not a consideration of the impacts that might draw from that degree of fiddling. In removing the requirement for corroboration, we have given no consideration to what has been described throughout this debate as a system of justice. And corroboration was acknowledged for centuries as a benchmark, a central part of that system. So when one interferes with the system, it's important that we look at the knock-on impacts to verdicts. Do we need 2 or 3 verdicts for the future? And the proposals from Michael McMahon has laid fallow there for many months, indeed years. Will it merely result in more trials, victims and witnesses going through an experience of a process with no hope of a conviction at the end of it? Indeed, as the Cabinet Secretary often describes, south of the border, and I presume he means England, the rates there are no better of convictions than the rates here.
Final minute.
So we should be consolidating where we stand here. We would like to see a situation where our witnesses and victims are given a fair hearing in the court, but we need the checks and balances provided by this government, not out for auction for members to offer alternatives, but sizable proposals which will put our minds at rest that what we do will make our system better and not merely give us a headline that we've changed something and thereby we have been seen to reform. Witnesses, when they give evidence in a situation where only their evidence becomes the source of some successful prosecution, it's beyond consideration that they will not be challenged very robustly in a future court. Their experience currently is pretty devastating, and I would like to think that in coming forward with some proposals, the Cabinet Secretary will not only listen, but he'll implement additional checks and balances in his final proposals and put all our minds at rest that in removing corroboration, it will be a better system. Thank you.
Thank you. I'm afraid we really do not have any extra time. Cabinet Secretary, can I now call you and ask you to use up 6 minutes, please, maximum?
Thank you, Deputy Presiding Officer. First of all, can I give Graham Pearson and the Labour benches that absolute assurance? We are at a junction of a debate today that's not the normal procedure that would be happening. It's a debate brought by the Conservatives. Normally we'd be having a stage 1 debate after matters had gone through the committee. We did ironically have the benefit of the Lord Justice Clerk giving evidence yesterday, but we're going to hear those members that are here. We'll be hearing from the Lord Advocate, they'll be hearing from the police, they'll be hearing from victims groups. So all this evidence can be brought out. So I can give them that, and I reaffirm my position that we're happy to look at any safeguards that may be forthcoming. Can I firstly say I was rather staggered by John Lamont's comment that there really didn't need to be any change. Did he not sit through all the consequences, the legislation, emergency legislation that we're required to have in this Parliament because of CADA? The situation changed because of CADA. It cannot stay the same. Not simply in some of the major cases where previously matters were brought and sexual offences saw some justice because people were able to be dealt with. The whole sexual contact took place in terms of corroboration because the witness would say, I did have sexual relationships with her, and that provided the corroboration. With CADA, we all know that on the advice of the lawyer, there is no comment made and there is no corroboration, and justice will not be given. That's at the very top magnitude of cases, but the same applies at a lower level. I was also gobsmacked to hear about the Tories about how we should improve corroboration. Well, that was put to the Lord Justice Clerk, and I think, to be fair to say, he was rather gobsmacked. It would also be fair to say that this matter has been underway since 2010 through the Lord Justice Clerk, by all means.
Margaret Mitchell. They're gobsmacked. Is it not true to say Lord Carling hadn't even given that proposal any consideration? And that's why today we're calling for a wider proposal, not definite decisions to be made, a wider independent review, so this important issue is fully debated.
Well, I don't see how corroboration can be improved. And as I say, despite there being several consultations since 2010, I do note that it does appear that the Tories have inputted not one iota or indeed a jot of paper. Doubtless they've just been saving it up, and we'll hear it in due course. I thought there was a very thoughtful speech from John Pentland. There are matters where I think it will be essential that we do require corroboration. I was dealing with papers last night that are very difficult in forensic science matters that he was referring to. I think we'll find that the Crown Office will give assurances that these matters that we've debated in this chamber that have caused great angst, where some matters are not a science, they're an art, will require to have additional evidence from another particular source. But equally, I think it was quite correctly pointed out by Sandra White that what we're talking about is the removal of the general requirement to stop the inanities that Mr Pearson will know, where it's not two forensic scientists speaking to what the autopsy was, it's two forensic scientists speaking to that's the label, that's the blood test or blood sample that was taken by a nurse, and this goes right through the justice system. Now, maybe the Tories say that we can tinker with that, then we can accept it. Well, I don't know which set the tariff, and then fundamentally when that becomes the fundamental matter, but I'll be interested to see. They also seem to be suggesting that maybe we could get rid of the test for some offences but not for others. Well, I'll be interested to see just how we deal with a situation where somebody's perhaps charged with rape, and then 6 months later they die. Mr Pearson, in his very extensive experience in the police, may very well have experienced that, where corroboration wasn't to have been required and subsequently did require to be there. So I think those who oppose Lord Carloway's position have to think that through. But equally, I think what we have to do is to recognise a new prosecutorial test, an evidential test, a quantitative test. Is there sufficient evidence that the accused was the perpetrator? Is there a qualitative assessment? Is the available evidence admissible, credible and reliable? Is there a reasonable prospect of conviction? And even thereafter, the Crown are expecting a public interest test. Is there a public interest in prosecuting it? So these safeguards will be played out, and I have no doubt when we hear from the Chief Constable, I have no doubt when we hear from the Lord Advocate, we will be able to allay the understandable concerns that Mr Pentland has, because I think he's right on that, but that will be dealt with, because it is quite clear from the Crown we are not talking about a situation where one witness says that's happened and there will be no other evidence at all. That is not the position. But what we are talking about is justice. This is not a moot point. When you go into a trial relating to somebody, whether they've been seriously assaulted, raped, or indeed just had other matters that are perhaps less stressful but still cause great angst to the individual who's the recipient, it's not a moot point to them. It's not simply a debate between our learned friends. It's not simply on a point of order or a motion, my lord, that this matter should be taken out. It matters to them that justice is delivered. By all means, Mr Pearson.
Final minute, Graham Pearson.
I'm very grateful to the Cabinet Secretary. Would you understand that one of the issues that we've raised with him is not so much the investigation and the first port of call, it's how the courts will deal with it, how juries will assess it, what does a jury look like, and how will the verdicts be achieved?
Cabinet Secretary.
Absolutely, and that's why we went out to consultation, why we have changed the verdict with the support of the judiciary there, and we're happy to look at other matters that may come either directly from Mr Pearson, Dr Murray, or indeed any other member of this Parliament. But it is not a moot point. This is about access to justice. Each and every one in this chamber as an elected member will have had people who came to them in their surgeries who did not get justice. We've had to wipe away the tears, we've had to give our sympathy, we've had to empathise with them and say there was no corroboration, there could be no prosecution. Justice was not delivered. There comes a time when scientific evidence moves on, when no other country instigates this, that we have to deliver justice to the victims. I stand fully beside Victim Support Scotland, Scottish Women's Aid, Rape Crisis Scotland, and all those others who say the time has come to get rid of this archaic method.
Thank you very much, Cabinet Secretary. And I now call on Annabel Goldie to wind up the debate in a maximum of 8 minutes, please.
Thank you, Deputy Presiding Officer. This has been a timely debate, and we've been discussing the abolition of corroboration, a long-standing and much-valued component of the law of evidence in Scotland. And can I thank members for their contributions, some I think more thoughtful and measured than others. Now, I speak as a former solicitor, but I'm no longer a member of the Law Society of Scotland, and I'm not in the role of solicitors. And in my years in this Parliament, it has been my privilege to take part in many important debates, but this one is preeminent, because corroboration finds itself in the dock, charged with being an irrelevance, an anachronism and an impediment to convictions. And these are very serious accusations, and I want to examine them. Now, traditionally in Scotland, there are two crucial facts requiring proof in every crime. Firstly, that the offence was committed, and secondly, that the accused committed it. So where does corroboration come into this? What is it? When did we get it? And why has it been considered so important to the law of evidence in Scotland and the presumption of innocence? Well, historically, it goes back to the New Testament, when it was developed to avoid the execution or capital punishment of innocent individuals. More recently, in the 18th and 19th centuries in Scotland, the rationale for corroboration became that a single witness is insufficient for proof. Or, to quote the founding authority in Scottish criminal law, David Hume, no one shall in any case be convicted on the testimony of a single witness. And as other members have indicated, corroboration underwent reform. It was developed as a theme of evidence. So by the 1950s, it was clear that two witnesses are not required to prove every fact in a case. Reference has been made to the Muroff doctrine, which allows corroboration by similar facts. And in cases of sexual offences, and can I just say this to Christine McKelvey, I do sympathise with what she is describing, but may I point out that the complainer's distress as observed by a third party after an alleged sexual offence can be used to corroborate the use of force or a lack of consent. And of course, there are now some statutory exemptions to the requirement for corroboration, which tend to relate to minor crimes such as road traffic offences. What does remain unchanged is the underlying principle of corroboration, that one version of events on its own is not enough. It is not safe. Now, Mr McCaskill says, oh, it's not just about one witness, but then what is it about? Because that is what I and others are now completely unclear about. Some of his own people think corroboration is not to be abolished. Mr McCaskill's amendment quite clearly says explicitly it is to be. Now, for modern purposes, Deputy Presiding Officer, the rule is based on the idea that it is better to let a few guilty people escape conviction than risk depriving an innocent person of their liberty. And the current authority in Scottish criminal law, Professor Gerald Gordon, puts it in a nutshell, and I quote, "We accept that sometimes a single witness can be reliable, and that by refusing to believe him, we may be doing injustice in the particular case. But we cannot always be sure about our judgments of reliability, and indeed, we are so likely to be wrong, and the results of our error are likely to be so serious that it is better to make it a rule that we shall never rely on only one witness, because on the whole, that will lead to less injustice than more reliance on our ability to detect unreliability." Now, how might the testimony of a witness be unreliable? Well, contrary to popular belief, witnesses do lie in court, and their motives may be sinister. Or they may be completely honest but quite simply wrong in what they thought they saw. Or they may get flustered in the tension of a courtroom environment and through anxiety or confusion misrepresent the actual position. And that is because giving evidence is a human process, and for whatever reasons, human beings are fallible. And yet, if corroboration is abolished, as we understand corroboration, none of that will be tested or challenged. Because the bastion of the accused's protection against such frailties, the guardian of the presumption of innocence, is corroboration. And that view is shared by all the groups mentioned in Margaret Mitchell's motion: lawyers, judges, groups of police officers, the Scottish Human Rights Commission, adult survivors of childhood sexual abuse, Justice Scotland. And on the matter of judges, what I would ask the Justice Committee to investigate is which judges actually support abolition, with the honourable exception of Lord Carloway. Now, why does corroboration find itself in the dock? Well, the Scottish Government, in the wake of Cadder, instructed Lord Carloway to carry out a review of criminal procedure. And that case gave rise to significant issues about detention, period of detention, and the right of the detainee to legal advice. And I disagree with Mr McCaskill. I don't think corroboration was central to the Cadder case. And Lord Carloway made numerous recommendations about Cadder, but prominent amongst them was the abolition of corroboration. And that's what we are talking about. And I say to Sandra White, if you're in any doubt, look at the text of your colleague's amendment. Now, what consultation, research or evidence-taking was engaged in to justify this conclusion? Nothing of any extent that I am able to discover. So the conclusion is largely subjective. Now, that in itself is not fatal. Lord Carloway is an eminent judge. But it does demand the most rigorous examination of the arguments advanced to support that conclusion. We are told that corroboration does not in practice service its stated purpose of preventing miscarriages of justice, that the real protection against this is the standard of proof required. No, it's not. If the standard of proof is beyond reasonable doubt, you still need reliable evidence to satisfy that test. A dishonest or mistaken or confused witness, in the absence of corroboration, could easily satisfy that test. Then corroboration is condemned because it concerns the quantity and not the quality. I'm very tight, Mr McCaskill, and I do apologise. I want to just develop this theme. It's condemned because it concerns the quantity and not the quality of testimony. Now, I have to say, Deputy Presiding Officer, when it comes to meaningless mantra, that takes the biscuit. When you are dealing with evidence, reduce the quantity and you will assuredly prejudice the quality as night follows day. Dishonest, wrong and confused testimony will prevail. What kind of quality is that? I wouldn't want to be at the mercy of that if I were the accused. Then we are told corroboration acts as an artificial barrier to prosecution, where the only potential evidence may be from the testimony of a single complainer. Well, yes, it does. That's actually a strength in our criminal justice system, not a weakness. And of course, abolishing corroboration will increase the number of prosecutions. But to imagine that will lead to more convictions is as naive as it is nonsensical. It will lead to greater doubt in the minds of juries, who may be much more inclined to acquit people who are guilty. How does that serve victims?
Final minute.
It will certainly lead to innocent people being convicted on dishonest or mistaken or confused testimony because their witness convinced the jury. And the other arguments advanced with the review do not merit abolition, but they do justify reform, Cabinet Secretary. I accept that. That's a different matter entirely, and I am sympathetic to that. And the motion in the name of my colleague Margaret Mitchell makes the investigation of that option a possibility. In conclusion, the Scottish Government is proposing to abolish corroboration on an analysis which is flawed, reasoning which is opaque, logic which is incoherent, and a conclusion which is plain wrong. The Scottish Government has no substantive alternative substitute or mitigating safeguard to offer, and that too is plain wrong. It's akin to demolishing the dam wall with no flood prevention measures in place. In my opinion, corroboration is innocent. It requires reform, but the charges against it have not been proved. We should keep it, we should reform it, and I support the motion.
Thank you very much. That concludes the debate on corroboration, and we move to the next item of business, which is a debate on motion number 7783 in the name of Liz Smith on named persons. Can I invite members who wish to participate in this debate to press the request to speak buttons now? And I must indicate at this stage that this debate is oversubscribed and we are extremely tight for time. I call on Liz Smith to speak to and move the motion in a maximum of 10 minutes, please.
Thank you, Deputy Presiding Officer. I don't think anybody who followed the Daniel Pelka case this summer could be anything other than repulsed by the depths of the depravity which had confronted this little boy as he struggled against the daily litany of abuse, starvation and isolation. His case was perhaps one of the most brutal examples of how society can fail with our most vulnerable children. Some will argue that this case was at the most extreme end of the scale, but it is by no means the only case where our youngest and most vulnerable children have been exposed to appalling neglect. So quite properly, there should be a national debate about how to protect our most vulnerable children. For some time, the Scottish Conservatives sat long and hard about what our reaction should be to that challenge, and more recently we've been reflecting on these issues in the context of the Children and Young People's Bill. As we made clear in an earlier debate, we agree with some of the stated intentions of the bill and some of its proposals. In particular, we agree that we should do more to increase a collaborative approach towards the care of children so as to ensure that children's services are delivered more effectively and with much better qualitative outcomes. We wholeheartedly agree with plans to extend childcare, making it easier for parents to get back to work and easing the financial pressures on hard-pressed families. And we wholeheartedly agree with providing greater backing for young carers and kinship carers, many of whom do tremendous work with very little support. Very specifically, however, we have examined the proposed legislation against the criteria of what defines good law. Is this piece of legislation necessary? Is it clear, coherent and effective? And is it accessible and therefore clearly understood? We contend that in the current form, the Children and Young People's Bill fails on several counts. But as well as that, the Minister knows that we have a fundamental concern about the unmistakable status philosophy which underpins the named person, a view which we believe is shared by some important stakeholders, including the Scottish Parent-Teacher Council, and I note they say in their latest newsletter that our worry is that giving every child a named person is at best a waste of time and money, and at worst could lead to unwelcome interference in family life. It's a view that's shared by CARE and by several key figures in the legal community. So it is on that basis that we have chosen to debate the named person this afternoon, after which we hope the Scottish Government will undertake an urgent review of its proposal. Let me deal first with our substantive objection to a named person for every child in the age 0 to 18. The rights of children do not stand in isolation. They should be seen in the context of the rights of parents and families and the responsibilities of these families, which must articulate with the needs of all the individuals within that family. For us, these are basic principles. Indeed, they are the principles which are meant to underpin so much of the thinking which is behind policies for children and young people, and they are the principles which underpin European legislation in this sphere. But within the interpretation of the current bill, there is a real danger that the balance could swing heavily behind the state rather than behind the parent. The Faculty of Advocates, when discussing clause 19(5) of the bill, say that this section of the bill dilutes the legal role of parents, whether or not there is any difficulty in the way that parents are fulfilling their statutory responsibilities. We share that concern. Also, in a legal context, Professor Norrie has made clear that the bill in its current state allows ministers to have more powers, which he says are open-ended and, in his view, not well defined. And whilst he acknowledged that some of these concerns might be a matter of semantics for the bill team, other aspects are not, and they open up the prospect of more state intervention. Again, that is something with which this Conservative Party is not comfortable. For example, the current bill currently identifies the child as being a young person up to age 18, which is not only contrary to other pieces of Scottish and UK legislation, but it involves complications. If young people can marry age 16, fight for their country up beyond age 16, then surely that raises questions about the appropriateness of a named person in that context. Indeed, we heard yesterday at the Education Committee from Bill Alexander of the Highland region, who incidentally is a strong supporter of the principle of the named person, that it is totally impractical in some of the older age groups, and it's not wanted. For us, implicit in this proposal to have a named person for every child is the insistence that the state has the primary obligation to look after the child rather than parents and families. That is entirely the wrong way round. If there are thousands of parents across Scotland doing a thoroughly good job, and there are, then what right does the Scottish Government have to put in place an intervention measure that tells them that the state knows better than parents and families? Of course.
I think Liz Smith is hugely misrepresenting what the intention is behind this bill, and I'll certainly make some remarks in my opening speech about what we do intend with this bill. But we have, through the early years, through our parent strategy, always engaged and listened to parents. It's not about telling people what they should do. This is about creating a structure which will help parents provide a support place for where they can access support if they need it. It's not about doing the things that Liz Smith is describing.
Well, if the Minister cares to read much of the evidence on this, there are deep-seated concerns, particularly amongst the legal community, about the interpretations. I've read out some of them this afternoon. These are serious concerns that the balance is going towards the state rather than with parents and families. But there is another concern, Deputy Presiding Officer. All political parties in this chamber rightly worry about how we can reach the most vulnerable children and provide additional resources where they are most needed. If through the named person policy we are insisting on state intervention for all children, even from families who do not require any help, then by definition we are going to end up by spreading resources for our most vulnerable children far too thinly. Mr John Stevenson of Unionist told the Education Committee on the 3rd of September that the bill would bring into the net a whole lot of people who had no previous connection with agencies at all. He is right, and that is supported by the wealth of evidence that has come to the committee, both in terms of education and the Finance Committee. Now, there are some who tell us that there is nothing to worry about, that this policy is just merely a formalisation of what is already happening, and it's just a means of expanding the successful Girfret project in Highland. I don't accept that. Indeed, it could be argued that the Highland success, and I think it's very fair to say that Highland has been successful, has come about without legislation, and because the authorities' culture of care has meant that the various departments have collaborated so well. If I just may finish this point, and if it was the case that it was just a formalisation of existing practice, then why would so many stakeholders, even if they approve of the principle of named person, be so anxious about its costs and its additional workload?
Stuart Maxwell.
I thank the member for taking the intervention. The member is on the Education Committee, the same as me. We have heard consistently over the last 2 years evidence, both in terms of legislation and also in terms of our inquiry into looked after children, about the problems about inconsistency of approach across the country. Doesn't the proposition that she's putting forward, that we don't use legislation, just actually end up with a situation where we have a good situation in the Highlands and Islands and a poor situation elsewhere? We end up with inconsistency across the country.
Liz Smith.
I don't accept that, because I think it's very clear from what's happened in Girfret and Highland that they have been hugely successful. We've heard many witnesses, and you've been in the same committee sessions as me, where it is about changing a culture rather than about having top-heavy legislation. Deputy Presiding Officer, my colleague Gavin Brown will explain about why we are very concerned about the costs of this proposal. something that again has been discussed in great depth at both the Finance Committee and the Education Committee. But there are other problems too. We've been frequently asked about how the named person will be chosen, specifically whether the parents or the child or both would have to have any input into that, what happens in the situation when relations break down between the named person and the family, and what will the relationship be with the named person and a lead professional, and whether there really will be a single point of contact. Then there is the issue over data sharing. In particular, concern about what was meant when it was said that information should be shared if it might be relevant. Well, what does that mean? Or to a child's well-being that it ought to be provided. What does that mean? The law officers are very clear that that is open-ended and it is simply not acceptable.
Final minute.
Deputy Presiding Officer, the Children and Young People's Bill contains some excellent policy commitments, including those which seek to address pressing issues in childcare, care leavers and kinship carers. But the bill, taken in its entirety, is designed to take an unacceptable degree of responsibility away from many parents and families. That is something which we fundamentally disagree with, as indeed do some powerful voices who I've referred to in my opening remarks. We would therefore want the Scottish Government to review its approach to the bill, specifically to ensure that the limited resources are targeted at the most vulnerable and that responsibility is placed in the right hands. In particular, we want the Scottish Government to review this policy on named persons, the issue which has already aroused the greatest degree of controversy and concern. Expecting all children to have a named person in the terms stated in the bill is an assault on the responsibility of families and parents for whose children there are no real problems. It is unnecessary and an undesirable intrusion of the state, and just as importantly, it threatens to take away resources from the most vulnerable. I move the motion in my name.
Many thanks. And I now call on Aileen Campbell to speak to and move Amendment 7783.2. Minister, maximum 7 minutes.
Okay, thank you, Presiding Officer. The Scottish Government believes that action must be taken to put in place a proportionate system of protection, nurture and support to give all our children the best chance of flourishing. And that's what we have done in the proposals within the Children and Young People Bill. I believe that a universal approach which looks to identify any issues, any concerns at an early stage and steps in appropriately to help children and their families tackle problems is essential. And this is getting it right for every child, or GIRFEC, an approach started by our predecessor administrations, supported over the years by all parties. And the named person is central to that approach, as vital to the GIRFEC as GPs and nurses are to the health service. In developing the proposals for the bill, we didn't start from scratch. The previous administration started GIRFEC with the Highland Pathfinder in 2006. As Bill Alexander said in his evidence before the Education Committee yesterday, we are not coming before you with an untested product. Practitioners already passionately believe that it works. When the Pathfinder project began, parents in Highlands said they wanted a person they can identify with. They wanted to avoid repeating their stories over and over and over again, and they wanted help and support when they needed it. And that is when the named person concept became an essential element of the Getting It Right for Every Child approach, developed with parents, not as a bottom-up approach that Liz Smith described.
Liz Smith.
For taking the intervention. Is it not the case that these parents are the parents of children who were requiring additional support, rather than those parents whose families did not have problems?
Minister.
I'll go on to talk about some more parental input into this process as I make some more progress with my opening remarks. And as the evidence from the Highland Council so eloquently put it critically, the named person is a point of contact for families where they can seek advice or support about issues relating to their child's well-being. She'll usually be someone with the family that the family already knows and who they feel able to approach. And as Liz Smith herself said in 2009 about the experience of Highland, I welcome the report on the result of the Highland Pathfinder GIRFEC project, especially the progress that has been made in making improvements in professional practice with the better multi-agency working and developing a more holistic approach to the needs of the child, something that we all agree is one of the most important issues. The named person role was the foundation for that more holistic approach in Highland and central to providing a more helpful response and the better coordination of support that we all recognise is absolutely vital to the well-being of our children. Now, a lot has been said this summer about the policy. The practice and the facts are as the named person relates to the family life. The Scottish Government knows the most important influence on a child's life are their parents. Our early years work, our parenting strategy are all evidence that we place the absolute highest value on the role of parents as the principal carers for their children and in listening and engaging with them. And that engagement with parents will continue as we take forward this bill. And as every parent, myself included, or carer knows, there are often challenges or concerns in bringing up children, and that is quite normal. Helping children and families cope with the challenges that life presents is part and parcel of everyday good practice by midwives, health visitors and school staff. And that's why, on that point...
Kezia Dugdale.
I wonder whether the Minister would say that she does need to do more to convince parents that this is a good idea. And if she accepts that, can she perhaps lay out how she plans to do that over the months ahead?
Minister.
Absolutely, and I think as the progression of the bill goes through the Parliament, we'll be able to make sure that our narrative does deal with some of the issues that parents feel. And absolutely, as I said earlier, that we want to engage with parents as much as we can through progression of this bill. No. And that is why I believe the named person service should be based in the universal services of health and then education. We're not changing what they do, we're changing how their roles are seen. And here's another quote from one authority on that matter. I remember one GP eloquently described how a health visitor could gain both the confidence of and enter a household into which that GP might not be invited. The GP was clear about the twin benefits of the health visitor. First, in being seen as a help to the household, and secondly, in being able to identify at an early stage any possible cause for concern in the household. Health visiting is a vital preventative service in the early years. And I couldn't agree more, and I'm grateful, and that was said by Annabel Goldie, who's still in the chamber, for that succinct summary of the role of the named person for each and every young children. Sometimes the concerns that parents of children raise need the attention... Oh, sorry, of course.
Annabel Goldie.
The context in which I made that observation was in relation to health visitors at the option of authorities being able to look at families where concerns were expressed. That's entirely different from the conferral of a named person upon families universally, whether they want that person or not.
Minister.
I think it's perhaps a bit of inconsistency from the Conservatives, who last session did seem to agree with all that we're trying to achieve with GIRFEC, and in this instance don't seem to reflect that previous position. Now, sometimes the concerns that parents or children raise need the attention of one or more professional or from different organisations or disciplines. They need help in navigating their way through the different services that are available. As one Edinburgh parent put it, for me, the concept of the named person works because I will have a named and known professional with whom I can communicate any concerns or share information. Parents are often frustrated and confused by not knowing who to contact or by frequently changing professional teams. At times of pressure or concern, clarity will be a real benefit. And we cannot forget the rare occasions when parents or families don't provide the right support and loving environment for their own children. The recent tragic cases of Daniel Pelka that Liz Smith mentioned have highlighted the importance of professionals putting the child's interest at the heart of what they do and communicating their concerns. Anne Houston of Children's First said, "Deaths like Daniel Pelka's remind us why the principle behind the named person is a sound one, as it aims to prevent children slipping through the net."
Final minute.
And I'm not claiming that the existence of the named person would necessarily prevent such tragedies, but as Ruth Wishart said in her excellent article in the Herald, she said it's unrealistic to suppose we can stop every incident of child abuse, identify every perpetrator, always intervene in time to prevent tragedy, but we can make a big difference. Now, issues have been raised around information sharing, and these cases highlight the importance of sharing where it is required to protect a child's well-being. Any sharing of information under the bill must take place fully within the framework set by the DPA and the European Convention of Human Rights. A preventative approach means taking action should be taken before things get serious, and the named person provides a structure for doing that. There have been issues raised around the cost of GIRFEC, and of course it's not always just about cost. We know that the GIRFEC approach is making savings, and we know from the Highland the kind of savings that have taken place. Reductions in social work caseload by 50%, reductions in referrals to the Children's Reporter by 70%, reductions in the number of children who have been accommodated, and we know that those areas which are the furthest advanced in implementing GIRFEC have found similar findings.
You must stop now,
over
please.
the years, Parliament has repeatedly endorsed the GIRFEC approach, and I hope that at the end of today we'll be able to do the same thing again.
Thank you very much. Now calling Jane Baxter to speak to and move Amendment 7783.1, maximum 5 minutes.
Thank you, Deputy Presiding Officer. I welcome the opportunity to open this debate for the Scottish Labour Party today, and I'd like to begin by saying that we support the principles of getting it right for every child and we welcome the move to incorporate elements of GIRFIC into statute. There are, however, a host of views on the issue of the named person, from the wide range of children's organisations that support the approach, to the concerns of parents and others about the rights and responsibilities of parents, the rights of children, the need to protect confidentiality, and the capacity of universal services, namely health and education, to take on the role. I believe that everyone in this chamber would want to see the bill give an absolute focus to how we can best support families and children, and in particular to improve the life chances of Scotland's poorest and most disadvantaged children. With this in mind, the Labour amendment highlights that we are still in the committee scrutiny stages of this legislation. Indeed, we are barely midway through stage 1. Members of the Education and Culture Committee have and will be hearing evidence about the philosophy, the principles and the practicalities of the named person approach, and I fully expect there to be a number of amendments lodged at later stages. So while it is so fresh in our minds, I propose to make reference to some of the evidence provided up to now to the Education and Culture Committee. Yesterday we heard from Highland Council, which was a pathfinder authority for GIRFIC in 2006. At that time there was no mention of a named person, but the value of the role did emerge as the model was developed and was fully implemented by the Council in 2010. Both the written and oral evidence from Highland to the committee have highlighted reduced bureaucracy, improvements in outcomes for children and families, and the empowerment of staff, which have arisen from the named person approach, and which have allowed them to reinvest resources in, for example, additional health visitors. It remains to be seen how transferable this experience would be to other parts of Scotland, especially given some of the resource concerns being widely expressed. Colleagues in the Finance Committee have provided scrutiny this week on the resource implication for this legislation and the assumptions made within the financial memorandum. For example, the issue of funding for training of education staff expected to carry out GIRFIC functions, and which seems to have been budgeted for as a one-off cost within the financial memorandum. Presumably, therefore, in later years, this is expected to be absorbed into budgets. But if the training is not seen as additional and funded appropriately, then something will have to give to make way for it in future years. But what? Training is clearly essential to enable the named person to adapt to a new role, but also to enable them to make a judgment on cases as they arise. And thus we see that the named person proposal clearly has implications for those staff who will be expected to take on the role. The EIS and the NSPCC have each raised concerns about resources, and the Royal College of Nursing has estimated that an additional 450 health visitors would be required to fulfil the requirements of the named person's role as outlined in the bill. Unison has stated, as they stand, the responsibilities will require additional frontline time and administrative support, and it is unlikely the agencies will be able to easily allocate those resources. Unison in the written evidence has highlighted the need for clarification of the role of a named person, and crucially, where and how it relates to the lead professional, and our amendment today calls for that clarity. In closing, it is clear from the number of questions being asked that the role of the named person must be further explained and clearly defined. There is a strong commitment from all sides to improving the life chances for children and families in Scotland, and I see the strong engagement around this issue as a measure of the commitment shown by organisations from the public and third sector in advocating on behalf of the children of Scotland.
Final minute.
I hope that many of the constructive suggestions which have been put forward will be listened to by the Scottish Government. What we have in the named person for every child is a nugget of a really good idea, but there are serious concerns that need to be addressed before the Labour benches can offer the Government support on this. I move the amendment in my name.
Many thanks. I'm afraid, in turning to the open debate, I have to advise the Chamber that this debate is oversubscribed and we may have to lose a member from the debate. Speeches of a maximum of 4 minutes. I call Stuart Maxwell to be followed by Ken McIntosh.
Thank you, Presiding Officer. Presiding Officer, unfortunately I have to begin by expressing my disappointment that we are having this debate at this time, and that the Conservative Group have brought a motion before Parliament opposing a policy that is currently being examined by the Education and Culture Committee as part of its examination of the Children and Young People Bill. The committee are in fact in the middle of taking evidence at stage 1. We have not yet heard all the evidence on the bill, or even on the named person and the information sharing parts of the bill. This debate, in my opinion, is premature, as it clearly preempts the committee's scrutiny of the bill.
Liz Smith.
Just like we had earlier this afternoon, is it not helpful to have a parliamentary debate to flesh out some of the concerns that have been raised already. We've already had 127 representations. I don't see any problem about having a debate about that.
Stuart Maxwell.
Well, sorry, but Liz Smith spent part of her contribution criticising specific points on the evidence about particular words within the definition of them. That's exactly the role of the committee, to examine that and report at stage 1 in its report, and us for debate that and then perhaps move amendments at stage 2. So that is the process and parliamentary process, and I think it is slightly disrespectful of the Conservative group to bring this debate at this time. However, we are where we are, and on the balance of the evidence the committee has received thus far, it's clear that there is widespread support for the introduction of the named person. In fact, only yesterday we heard very strong evidence from Mr Bill Alexander from Highland Council, the national pathfinder for the implementation of GIRFEC, about the positive impact of GIRFEC, including information sharing and the named person. I would ask the Conservative group to really look at the evidence and the organisations supporting the named person. Organisations like Bernardo's, NSPCC, Children First, RCN, Aberlour, YouthLink and many others. Of course, there are legitimate questions to be asked, but that is what the committee is doing. That is what it's looking at. That is the committee's role. The NSPCC have stated NSPC Scotland support the aspiration embodied in the role of the named person and considers that a single significant individual could deliver a positive, consistent and nurturing relationship throughout the child's journey. So what is the named person? I want to quote from the Children in Scotland briefing. The named person is a key element of GIRFEC, ensuring that there is a point of contact for every child and their parents' carers to enable well-being concerns to be considered in the round and appropriate early support and early intervention to be delivered if required. The named person is not a social worker in every home. It is not attacking the rights of parents, and it's not diminishing the central role of the family. It is, however, about protecting children. It is about putting the child at the centre of everything we do and really meaning it. The Education and Culture Committee has just spent 2 years looking at looked after children, publishing our latest report only 2 days ago. If members have read that report, then they would understand why we need to make progress in child protection, why we need to implement GIRFEC across the country, and why information sharing and the central role of the named person are crucial to the success of GIRFEC. I accept that there are those who remain to be convinced, so perhaps we need to be looking at this issue as prevention being better than cure. In other words, we put measures in place to protect children from harm, although we hope and we know that the vast majority of children will never need that protection. If even one child's life is saved, isn't that worth it? For example, we give vaccines to babies, even though lots of them will never be exposed to the diseases that these vaccines prevent. We understand it doesn't do any harm, but if needed, it will in fact do a great deal of good. Why is the same not true for the named person? Who in their right mind would argue against any effort by the government or any other authority to protect our children? If we are really serious about putting child protection at the heart of everything we do, then it is only right that we put in place the best system that we can. The evidence to date is that GIRFEC is that system, and the named person and information sharing are indispensable elements of it.
Many thanks. Ken McIntosh, to be followed by Claire Adamson.
Thank you, Presiding Officer. I find myself in unfamiliar territory today. I've always supported the GIRFEC approach to child protection and continue to back the principles behind getting it right for every child. I would normally find myself on the side of the children's organisations who have lobbied MSPs before today's debate, and I certainly wouldn't describe myself as having a knee-jerk opposition to state intervention. Having said all that, however, I should also say not only that I both recognise but that I share the concerns raised in the Tory motion this afternoon. My instinct as a parent, my instincts are to question the need for all children and their families to be allocated a named person when it is the few who are at risk. And my main worry is that despite the best of intentions, the whole exercise could end up diverting scarce resources away from the children most in need. Now, I am sure there are few people across Scotland, let alone in this chamber, who fail to recognise the need to protect and help our most vulnerable children. The national news is filled too often by stories of neglect and abuse and the all too horrific consequence of children dying at the hands of their own parents. But I find it difficult to see how appointing a named person to look after, for example, each of my 6 children, those of Gavin Brown, or dare I say of the Minister, how will that do anything to improve child protection or to prevent such deaths occurring again? I simply fail to follow the argument that by giving a health visitor or a teacher responsibility for, let's say, 30 well-brought-up children, or dare I even say not very well-brought-up children, How will that help them recognise the one that needs support and intervention? What is worse is that time spent filling in forms for 30 children who will never need any intervention is time that could be better spent on those children in desperate need of help. Resources diverted to children who are thriving, loved and nurtured are resources not spent on the neglected and the vulnerable.
Minister.
Minister.
Again, I think Ken McIntosh is grossly misrepresenting what the named person is. It's not about, there are many times and many instances where people like your children, like my children, where we wouldn't need the named person, but that person is there if you ever do feel that you've got a point of concern or anything, that you can proactively seek that comfort from that person. It's not about everyone having to use the named person.
Ken McIntosh.
I have no difficulty accessing my teacher, my health visitor, or anybody else, and I don't see why they have to be a named person. This does not seem to offer any additional benefit. As far as I'm aware, teachers already have a professional duty, an ethical and a legal obligation to pick up on kids who are turning up late for school, badly fed, poorly dressed, or otherwise showing signs of lack of care. The same duty applies even more clearly to health visitors. Now, how does seeking assurance from those same teachers that the vast majority of children in their care do not need help in any way assist them in identifying those in danger of slipping through the net? Is there not an obvious risk of creating an administratively cumbersome and bureaucratically complex system, but with no additional practical benefit?
Final minute.
Will there be a file for every child? Who will keep that file? What happens when staff move on, as they often do? At the very least, we need to clarify what this additional duty as a named person will mean. Now, I would put my concerns to one side if I thought the named person approach would save one life or pick up on one example of child cruelty or neglect that would otherwise go undetected or unrecognised. But if we look at all the recent cases of child abuse, as far as I can recall, every subsequent inquiry concluded that where the state failed to intervene early enough, it was not because no one knew about the risk, it was because of the failure to share information. One of the main recommendations as a result has been to identify a lead professional in every case. If every child is to have a named person, is there not a distinct possibility that we will create masses of information telling us nothing more than most children are fine, whilst potentially confusing lines of responsibility between the named person and the lead professional?
You must finish.
The children's countries have argued, and I've finished here, have argued that the measures are in line with GIRFIC. But as I recall, GIRFIC was originally based on a report called "It's everyone's job to make sure I'm all right," not "It's one named person's job to make sure I'm all right."
Thank you. Can I repeat to members I have no extra time available in this debate, no seconds at all. Gavin Brown to be followed by George Adam.
Thank you, Deputy Presiding Officer. I want to focus the bulk of my remarks looking at the financial memorandum that sits alongside the bill, and particularly the aspect in relation to the named person, because the Minister, in her contribution, towards the end of her contribution, suggested there would be quite significant savings quite quickly, and that's the evidence put forward in the financial memorandum. All well and good, except almost everybody who has contributed to the process, whether it was to the Education Committee or whether it is to the Finance Committee, disagrees with the proposition put forward in the financial memorandum. We hear in that memorandum that by giving 700,000 or so children aged between 5 or 18, via the local authority, a named person, we will have a cost of about £7.8 million in year one. This is because it creates 247,613 additional hours over the course of that year. So over 200,000 hours at a cost of £8 million. Yet, according to the Scottish Government, the cost of these extra 200,000 hours in year two will be £0 and 0 pence. Now, the Minister may shake her head at that, but I'm quoting directly from her financial memorandum. If she doesn't like it, if she disagrees with it, she is quite welcome to stand up and intervene and to say so. But the Government's financial memorandum, the Government's position is that there will be no cost at all to local authorities in year two of their proposition. They say this because at the end of year one, the system change will quite simply bed in. Now, COSLA, on whom they relied to quite a heavy degree in terms of doing the pre-work for this, don't agree with this. COSLA are extremely clear in their proposition, their submission to the Finance Committee that this £7.8 million of cost identified for staff time should be funded on a recurring basis. The Scottish Government's propositions are speculative, and they make out the point that it's not the experience of some local authorities that implementing GIRFIC is reducing the number of meetings or administration. So COSLA, who are representing the 32 local authorities, are saying quite clearly that this cost is recurring, yet the Scottish Government's position is that there will not be a single penny spent in year 2 on this because it is bedridden. Sure, happy to give way.
Stuart Maxwell.
Very briefly. Perhaps the member missed the evidence from Bill Alexander of Highland Council about the National Pathfinder project, where GIRFIC has been embedded in the system, who made it very clear about the cost savings, the time savings, the bureaucracy savings, the cuts in meetings, the number of hours savings right across the board, explained very clearly by Mr Alexander.
Gavin Brown, and you must finish shortly.
I'm grateful for the intervention there. I'd say 2 things there. The first one is the written submission from Highland Council. There is a separate case to be made about how many health visitors and teachers are required to fulfil the full range of responsibilities of these tasks. And secondly, I'd point out quite clearly that while Highland Council put forward that it was a success, they did not say that at the end of year 1, there was 0 cost to them. There was 2 years of pre-work. There was 18 months after that of implementation. Even the Highland Council, on whom their entire case appears to rely, have not said at any point that there will be 0 cost to this by year 2. And so it's for the Scottish Government to defend in their closing how on earth they reach this conclusion and why nobody agrees with them on it. Thank you.
Thank you very much. I apologise to the Chamber. I had indicated I would call Claire Adamson, so I'm now going to do so. Claire Adamson, followed by Gavin Brown. Sorry, George Adam.
Thank you, Presiding Officer. I am not a number, I am a free man. That quote will be instantly recognisable to fans of the 1960s science fiction series The Prisoner, and perhaps also the odd Iron Maiden fan in the chamber today. But of course, the use of the number to identify individuals in this series is used to heighten the surreal, dehumanising nature of a seeming idyllic village in which the protagonist finds himself. And there are many such examples in literature. Victor Hugo's Les Miserables, where Inspector Javert refers to the hero Jean Valjean by a prison number only. Or the taking of the name Kunta Kinte to be replaced by a slave name in the semi-autobiographical Roots by Alex Haley. And Margaret Atwood's A Handmaid's Tale, where women's names are eliminated and diminished to being of Fred or of Glenn, of the man who controls them. And Liz Smith has reminded us by mentioning Daniel Pelka that the human race can be very, very cruel, and to our shame, it has understood the dehumanising effect of taking a name, like the branding of slaves, tattooing of victims in Belsen or Auschwitz or other concentration camps. The Presiding Officer, what are artists in seeking to challenge our understanding of humanity, and those with the most evil intent in our history have understood, is the power of a name. How deep in the psyche as human beings, as social beings, a name or the removal or denial of it can be. So if we can recognise the power of the denial of a name, we must also recognise in this chamber how powerful the giving of a name can be. Presiding Officer, I believe that the proposals for a named person that are included in the Children and Young People's Bill have the powers to be transformational in how society, professional, families, children and young people interact as we move towards the full implementation of getting it right for every child. We took evidence yesterday at the Education and Culture Committee. Kate Higgins of Children First talked about the reluctance of some kinship carers to engage with this system. That's a position of alienation, a disengagement. But Bill Alexander from Highland Council, who have very successfully implemented getting it right for every child, used the phrase, "That is the power of the named person." That is the power of the named person. And I believe that this is a powerful development as we move towards the implementation of getting it right for every child, introduced by Labour and carried forward by SNP governments. Bill Alexander explained that named person, by and large, is the formalisation of good practice of what professionals have been doing for the majority of families. This change will be seamless, as the engagement of most families will be no different than it is at the moment. But where it will make a difference is where a family is in need. They need help or advice, and they now have a named person to contact. Not a school building, not a helpline, not a job title, a named person. Someone who knows them and who has had the most fundamental exchanges of an introduction, an exchange of names. And so that named person is someone known to them, someone in their community, and someone that they know will have the well-being, under the Shinari principles, at the heart of everything they do in their engagement with this family. I look forward to this powerful movement towards a named person.
Many thanks. And I call George Adam.
Thank you, Presiding Officer. Presiding Officer, sometimes I worry about this place. We're talking about proactively helping children across our communities and our nation, and some members are bringing it down to sheer pounds, shillings and pence and costs. Now that's very important, but as Stuart Maxwell and Jane Baxter quite rightly explained, we are going through the process at the moment within the committee structure, so that is our time to debate that and ensure that we get everything right, because let's not forget, this is an extremely important, the named person is an extremely important part of the GIRFEC principles, and many of the individuals who have given evidence to the committee have stated that. There have been many myths actually brought about with regards to this, and it's too easy to actually hit certain ideas, especially certain radical ideas that can make a difference. And one of them is such as like a state-appointed parent. Well, nothing could be further from the truth. It's an opportunity for communication between a family and others and professionals to be able to engage. I've actually not got much time, Ms Smith, so I'd like to continue. But it's to engage with everyone to ensure that they can actually make sure that some of the tragic cases that have happened over the years don't happen. Now, that doesn't mean you can legislate these things out of existence. That just won't happen. But we have to make sure that we can actually find a way to make things better and support many of the children and young people within it. Much has been said about Bill Alexander, the Director of Health and Social Care at Highland and Highland Council. And he came yesterday and he was very excited and said it was such an important part of the GIRFEC proposal that they did. He actually said, we do not get complaints about the named person's role being deployed. We get complaints from parents who believe it has not been deployed. Now, that's individuals and parents and families who have actually seen it working and seen that this can make a difference within the whole idea. Now, this was implemented by Highland Council in 2010, and it's been a great success. Named person means there is now a clear process to ensure information about the child is passed to the right person. No more going, unlike some of the other members who said they felt as if it would be information would be going back and forward and no one would know. This one individual would be the person that would be the conduit for all these concerns. Where concerns were often previously referred to the wrong agencies, resulting in the children's hearing system being swamped with inappropriate referrals, that is now less of an issue. And this is something that's come up quite a lot in the committee's work over the past year as well. And we have to make sure that if we're going to do anything, we have to make sure we get a system that's robust and can make a difference, because we're talking about, quite literally, people's lives and children's lives and families, how they do a thing. Their submission from Highland Council actually stated that the consequences of this being the named person has been earlier support and more effective intervention for more children. Getting the support to a child early usually means it is more likely to lead to a successful outcome. Now, surely, Presiding Officer, that is what we're here for, is to ensure that we can get this policy correct. Now, I would like to say that we can have these debates about how we make this policy robust and how we make this bill actually something that can work in our communities, but we have to get it right, and we have to ensure that we do it through the actual process, which is the committee, not showboating in a Parliament chamber trying to actually get one up on a political party. And in closing, Presiding Officer, I would just like to say that this is too important for any form of showboating. We need to proactively embrace the GIRFEC principles. The named person is part of that ambition for our nation's children, and let's all work together, ensuring that we can do the best for Scotland's children.
Thank you. Timing perfect. I call Keza Dugdale. Ms Dugdale.
Sorry, I'm McTaggart. I can only give you 2 minutes.
Okay,
sorry.
Thank you, Presiding Officer. The rights of children and young people and their well-being is something I know that every member in this chamber is passionate about, and I hope that the Children and Young People Bill will prove to be a positive step in making Scotland the best possible place for children to grow up in. The issue of the named person, however, is one that I am cautious about. I have spoken with a wide range of professionals from across the board on this subject, and many of them share my concerns also. First of all, becoming a named person is a huge responsibility for someone to take on, and these people need to have impeccable expertise and knowledge of their duties and their responsibilities, and we must ensure that there is adequate training in place for these people to do this properly. The cost of the additional resources, which has been mentioned earlier, is also of great concern. Several agencies that also have been mentioned, as COSLA, only last week, have expressed their reservations about the accuracy of the projected costs of the bill. The unpredictability of the cost stems from the fact that there is dependent upon the number of hours that individuals are expected to spend carrying out the role. In addition, we must also be aware that there are significant challenges in terms of ensuring solid communication links between the professionals involved. There will need to be and should be a high level of cooperation between the relevant local authorities. Whilst this is possible, it is difficult, and we must ensure that the proper systems are in place that can make this possible. To conclude, Presiding Officer, there are some serious issues regarding its practicality that we must resolve before this bill is passed. Placing an unmanageable workload on workers already under pressure can prove to be disastrous for both children and families and for their workers. Thank you.
Thank you. That was perfect. Kevin Stewart, you've got 2 minutes.
Thank you, Presiding Officer. We've already heard this afternoon about the Daniel Pelka case, and the Deputy Leader of the Conservative group in Coventry Council said, now is the time to have a radical look at the legal framework surrounding child protection. And I agree with that. And so far, over the years, we have had cross-party support for GERFEC, and I hope that that continues. I have to say that in terms of the Conservative motion, I certainly would not be supportive of anything that undermines the role of parents. And I think that this can actually help parents in a lot of regards. It may well be that Mr McIntosh has the ability to approach health visitors and teachers and all of the rest of it. Mr McIntosh is a particularly articulate man who knows the ropes. Not everybody knows the ropes, so what is the difficulty in providing each family with a named person that they may or may not use to get the information and the help that they need? This debate has had some pejorative language from the Conservatives. That doesn't surprise me. It is always the case that they talk about the nanny state and too expensive. Martin Crew of Bernardo, Scotland, says that these things would come up. And neither of these criticisms is justified, he said. Depending on the age of the child, a health visitor or teacher will usually take on the role and in most cases will not do no more than they do now. So rather than the pejorative language, rather than some of the silly things that have come up today, let's unite again round about the principles of GERFEC. Let's let the Education Committee do its job and hear the evidence, and let's come back here at a later date and forget the pejorative nonsense that has gone on here today. Thank you, Presiding Officer.
Thank you, Mr Stewart. The timing's getting better. I call Kaiser Digley. We've got 4 minutes.
Thank you very much, Presiding Officer. Can I start by welcoming Jane Baxter to our front bench role? She's both a mum and a gran and comes to the Chamber with 20 years' worth of experience in local government and a wealth of knowledge to add, not just to Parliament, to this bill in particular. So I'd just like the official report to recognise that. Whilst I've not been a member of the committee or indeed involved in this brief for very long, I have followed this bill's progress right from the beginning of my election as the convener of the cross-party group on children and young people, and I have seen it start from being 2 bills down to 1, and indeed many of its ambitions being diluted. And I do want it to work. I want this to be a good bill. I want it to deliver for young people across the country. And I've said to the Minister before, and I'll say it again, we are listening and we are working with you. We would like to see this ambition of this bill realised, but you have to listen to us and you have to listen to the sector who come to the table with legitimate concerns. And many of those legitimate concerns are addressed in Labour's motion today. There is no doubt that there is widespread support for the named person element of the bill from the children's sector, and can I say to all those groups that have provided evidence to the committee and have lobbied MSPs that their evidence is really welcome. But I also think it's been a great move to see the children's sector come together and speak to one voice, all uniting behind one briefing. I think in so doing their voice is more powerful, and I would encourage them to do so again in the future. There is, of course, recognised in Labour's motions concern about parents' feelings towards the named person element, and they were well articulated by Ken McIntosh. It's about, in part, intrusion. It's also about whether a named person is truly necessary for children who come from stable and loving homes. And I have some degree of sympathy with that. But there is a sense that there's a degree of ignorance behind some people's opposition to the named person bill. And I know that that's a view that Aileen Campbell would share. However, I have to say to her, it's up to her to sell this policy to the public, to the children's charities, and I would like to see her do a bigger job of that. I think so far she's failing to articulate what a named person really is and means, and she's failing to rebut some of the criticisms that are coming across in the press. So I have a bit of advice to her. I'm sorry, I only have 4 minutes on today's occasion. I wondered, Presiding Officer, whether she might think of recording a video like Mike Russell. I thought she could record a video about the named person element and perhaps have it played in assemblies and schools across the country. However, the definition of the role of named person is very, very important, and our motion recognises the degree to which we need to see that clearly defined, not just in terms of what a named person would do, but also to distinguish it from what a lead professional is. And at the moment, I'm afraid that message is not coming out loud enough and clear enough from the Scottish Government to alleviate some of those concerns. There are also significant concerns about the degree to which the named person is financed and resourced, and they were well made by Gavin Brown. And I would ask her to listen very carefully to what my colleague Anne McTaggart had to say today. Anne comes to the Chamber with years of experience as a social worker. When she says that people at the front line need to understand what their role and responsibilities are, you should be listening very carefully to that and making sure that that message is understood by all the professionals involved in this. It will be, come 5 o'clock, Presiding Officer, the Labour Party's decision to abstain on this motion tonight, quite frankly because we are still listening, our mind isn't made up. We would like to be persuaded of the Government's case, but I'm afraid they need to do a better job of articulating it. They don't just have to sell it to us. They can pass this bill without the votes of the Labour Party or without the votes of the Conservatives. But in order for it to work, they have to get the support of parents across the country, of professionals on the front line, and so far I'm afraid she's not winning that argument. Thank you.
I now call on Aileen Campbell. Ms Campbell, you have 6 minutes.
Thank you, Presiding Officer. And also, although I didn't do it earlier, welcome to Jane Baxter for her new role, and wish her all the very best in that. And, I think, it was a bit unfortunate, maybe some of the tone of what Kezia said there, because absolutely this is what the whole process of going through a bill process in Parliament is all about. It's about listening to views and making sure we take on board. So where people like Anne McTaggart or Jane have a real interest and a real expertise, absolutely we'll make sure we engage with that. And I know that I'm due to meet Jane Baxter in the next week or so to talk to her about her views on the bill. Now, recently it became clear that there were widespread misconceptions about what the named person's service really meant, some of which were stoked up by the tone, or the unfortunate tone, I think, of the reporting by certain parts of the press. The evidence that the Education and Culture Committee has heard so far, I think, has helped greatly to dispel some of those misperceptions about what the main person actually is. And I think it has been good to have been able to be receiving some of the fantastic briefings from many of the children's charities who have looked to make sure that everyone's aware of just how far and how much behind this proposal they actually are. Now, I look forward to being able to discuss the bill, including the named person provision, in light of all the evidence that has been presented and the committee's own assessment of its merit. And we can also then place the issue of the named person more properly in the context of all the improvements that the bill seeks to make. Now, I think we're all agreed that we should do absolutely everything we can to improve the life chances of our children and young people. The benefits to be gained from investing in the early years in providing all our children with the protection, nurture and the support that they need are immense. We did our own bespoke economic modelling. For every £1 that we invest in the early years saves us £9 in cure. And I think that's maybe something maybe Gavin Brown would be certainly interested in terms of the points he raised on the financial memorandum.
Gavin Brown.
To the Minister for giving way. I'm well aware of what early intervention is, but how quickly is that return made on the evidence that she has seen?
Minister.
I think you can make, there's the earlier collaborative, we're already seeing good examples of where that return is being made. And in response to Gavin Brown's points that he made, his assertions that he made through his opening remarks, that no one agrees with the savings for GIRFIC, but that's not the case. Edinburgh City Council, Fife and South Ayrshire councils have very real experience of GIRFIC, and it's through consultation with them that we developed and others we developed the financial memorandum. So I think he's it's very unfortunate that he has raised such assertions.
Gavin Brown.
Any of those councils say that there would be zero cost in year 2?
Ms Campbell.
And I think what we need to make sure is, though, is that the thing that we're talking about here, though, is about GIRFIC being an approach that does save the public purse an awful lot of money. We've heard from the Highland Council, and we've made sure that we've done an awful lot of work to make sure that our financial memorandum is robust as it can be. And I know that he took evidence in his role as convener or deputy convener within the Finance Committee. Now, but I do think, going back to what I said earlier, early intervention is by far the most effective way to secure sustainable improvements in the life chances of our children. So I'm confused. I am genuinely confused by some of the statements that have been made by certain members today. They say that they welcome the renewed focus on GIRFIC and that the philosophy underpinning it is admirable. They cite the benefits of early intervention. They agree that there should be much more joined-up working between all agencies involved in supporting children, yet at the same time they don't want to put in place the tried and tested mechanisms for achieving those benefits. If we want to get it right for every child, then surely there must be a role for the universal services of health and education to give the safety net that is needed. If services need to be coordinated around the child, someone needs to take responsibility to see that that coordination takes place. If success depends on spotting issues early and taking appropriate and proportionate action, then we need to put in place clear responsibilities and processes for doing that. If we need to get better at helping parents and carers navigate their way through the different services available, then there needs to be a readily identifiable professional there to help them do it. And if, in the most troubling cases, someone has a real concern that a child's well-being is under threat, then they need to know who to raise that concern with. And remember, the named person approach grew out of the experience of parents and carers themselves who sought the certainty of contact, that helping hand, that professional friend that the named person will provide. And as the evaluation of the Highland Pathfinder shows, families have shown that they have greatly valued that role.
Very grateful to the Minister for taking an intervention. I don't have a principled objection to the named person. I thought Bill Alexander's testimony was very helpful, but I think what we haven't identified is an answer to the question about taking our eye off the ball in terms of those who are most vulnerable and whose welfare is at issue, and actually in terms of the well-being, that isn't a trigger set so low that we have information flows that are wholly inappropriate and information being shared by people who really don't need to have that information. Minister, you're in your last minute.
Thank you for making that intervention. However, there is in place, we've had already through information from the Information Commissioner a letter that's gone out to make sure that only when it's proportionate should information be shared. But the whole purpose of being able to act early is to make sure that you can spot things and signs that may arise and to be able to act early, because the worst thing to happen would be you responding to something that happens far too late and before a problem where you can deal with a problem before it escalates into a crisis. Now, many members have made very good contributions today. Stuart Maxwell quoted Children in Scotland and reiterated the fact that the named person is part and parcel of GIRFIC. Claire Adamson, George Adams spoke passionately about the critical importance of GIRFIC and about the named person as being part of that, about getting robust structures in place to support that. And McTaggart talked about making sure that we engage with parents as well.
6 minutes is
and
up.
we are working with the National Parent Forum to help provide that advice. Now, we are wanting want to work with everyone to make sure this bill is a success. It's in the best interest of the children that we want to make sure that we can engage with everyone. We have done that in the consultation process. We'll continue to engage, we'll continue to listen and make the case for the named person as part of making Scotland the best place in the world to grow up.
I call on Liz Smith to wind up the debate. Ms Smith, I can give you till 5 o'clock.
Thank you, Presiding Officer. I think this has generally been a helpful debate, although I have to say I'm disappointed and rather surprised by the comments from some members that we shouldn't be debating this. What is a parliament for if it's not for debating the issues of the day? And I think that in the context of the many very good debates, contributions that we've had from various sides in this, I think it's proved the point that this debate was worthwhile because it is fleshing out many of the points that we have received in evidence. Indeed, many people, as they have debated, have referred to these points. So I am entirely comfortable, just as we were in the corroboration debate this afternoon, that it is the right thing to do, because that is our duty to scrutinise what is going on. And I'm grateful to the other parties for spelling out what their position is on an important topic and one which has clearly sparked a great deal of controversy. Not surprising in our view. In debating children and young people, many have said that what really is required is a change in the culture of thinking, rather than introducing a piece of very heavy and costly legislation. As mentioned earlier and has been spoken about several times in this debate, I think I'm going to have to give way to something else in a minute.
Can whoever has got a phone on put it off now? Ms Campbell.
I won't mention Alec Johnson there, who's trying to hurriedly scurry about and help sort his phone. But Liz Smith will know that the GIRFEC approach has been around since the previous administration. But there is that inconsistency of approach around the whole of the country. We've heard about fantastic things that are going on in Highland, but we need that consistency for children across the 32 local authorities. Does she not agree that underpinning this in legislation will help up the pace of change and improve that consistency?
Ms Smith?
No, I don't, Minister, and I said this in my earlier speech. I don't accept that, because GIRFEC in Highland has been a huge success, but it's been that without the legislation. And I don't often find myself agreeing with Ken McIntosh, but on this occasion I do, because he has eloquently spoken about the concerns about this legislation, which is actually echoed, and nobody in the SNP this afternoon has answered this question. The Faculty of Advocates are very clear in what they say about a section of the Bill 19.5, that it will dilute the legal role of parents, whether or not there is any difficulty in the way that parents are fulfilling their statutory responsibilities. That is a very clear comment from the legal experts. We share that concern. Now, on the substantive points, we really do believe that there is a fundamental issue at stake about the state having primary importance over the parent. The rights of children do not stand in isolation. They must be seen in the context of the rights of parents and families, and the responsibilities of these families have to articulate with the needs of all these individuals within that family. These are absolutely basic principles, and they are the principles which underpin so much of the law. Can I just come to the point about the costs? Gavin Brown has explained very clearly about the issue on the costs. And that is something that came through loud and clear at the Finance Committee last week. Because, without exception, when the members of that committee were questioning the Bill team about the financial memorandum, there was virtually no evidence that was put forward by the Bill team that could substantiate the claims about the costs. John Mason and Michael McMahon and Gavin Brown and Malcolm Chisholm all asked several times about that financial memorandum. And it's quite clear that the Scottish Government has not thought through exactly what these costs are going to be. Now, Presiding Officer, could I come to the point about the whole health visitor strategy? For some time now, the Scottish Conservatives have advocated a universal GP-led health visitor system for all 0 to 5s. And we are very persuaded indeed by the arguments currently being made by both the Royal College of Nursing and the Royal College of Midwives that a national system of health visitors will
Ms Smith, can I just stop you for a moment? There's far too much noise in the chamber. For those coming into the chamber, could you please have courtesy to listen?
Thank you, Presiding Officer. that evidence that's been submitted by the Royal College of Nursing and the Royal College of Midwives about a national system of health visitors will do more than anything else to tackle some of Scotland's worst health problems and to look out for our most vulnerable children at the earliest stage. The Ipsos Mori poll of 2010 made it very clear that this is an enormously popular policy because of the very high level of trust that parents put in these key professionals, because they are able to provide them with the essential advice and information that they require. 9 out of 10 of these parents within the survey said that they were very assured by the health visitor and the services that he or she provides. And if proof was needed of the value of such a policy, it was surely the results of the 2012 Scottish Health Survey published yesterday, which show very clearly that the key messages about health in Scotland are still not being acted upon under this government. Trying to deal, if I may just finish, trying to deal with these severe problems in later ages is simply not working. And that is why we are very clear indeed about our policy that there needs to be a national universal health visitor policy attached to GP service. Indeed, Alex Neil himself said that failure to intervene effectively to address the complex needs in the early years can result in a 9-fold increase in direct public costs over the long term. These are stark statistics upon which we need to act. Presiding Officer, may I finish on the point that that system would be far superior to the named person policy. Thank you.
Thank you, Ms Smith. That concludes the debate on named persons. The next item of business is consideration of Business Motion 7798 in the name of Joe Fitzpatrick on behalf of the Parliamentary Bureau, setting out a Stage 2 timetable for the Scottish Independence Referendum Bill. Any member who wishes to speak against the motion should press the request to speak button now. And I call on Joe Fitzpatrick to move motion number 7798.
Formally moved.
No member has asked to speak against the motion, therefore I now put the question to the Chamber. The question is that motion number 7798 in the name of Joe Fitzpatrick be agreed to. Are we all agreed? Yes. The motion is therefore agreed to. The next item of business is consideration of Business Motion 7797 in the name of Joe Fitzpatrick on behalf of the Parliamentary Bureau, setting out a business programme. Any member who wishes to speak against the motion should press the request to speak button now. And I call on Joe Fitzpatrick to move motion number 7797.
Moved.
No member has asked to speak against the motion, therefore I now put the question to the Chamber. The question is, the motion number 7797 in the name of Joe Fitzpatrick be agreed to. Are we all agreed? The motion is therefore agreed to. There are 6 questions to be put as a result of today's business. I would wish to remind members that in relation to the debate on corroboration, if the amendment in the name of Kenny McCaskill is agreed, the amendment in the name of Graham Pearson fails. The first question is amendment number 7791.3 in the name of Kenny McCaskill, which seeks to amend motion number 7791 in the name of Margaret Mitchell on corroboration be agreed to. Are we all agreed? Yes. The Parliament is not agreed. We move to a vote. Members should cast their votes now. The result of the vote on amendment number 7791.3 in the name of Kenny McCaskill is as follows. Yes, 62, no, 23. There were 30 abstentions. The amendment is therefore agreed to and the amendment in the name of Graham Pearson falls. The next question is amendment number... The next question is motion number 7791 in the name of Margaret Mitchell as amended on corroboration be agreed to. Are we all agreed? Yes. The Parliament is not agreed. We move to a vote. Members should cast their votes now. The result of the vote on motion number 7791 as amended in the name of Margaret Mitchell is as follows. Yes, 62. No, 23. There were 29 abstentions. And the motion as amended is therefore agreed to. I would wish to remind members that in relation to the debate on named persons, if the amendment in the name of Aileen Campbell is agreed, the amendment in the name of Jane Baxter falls. The next question, therefore, is amendment number 7783.2 in the name of Aileen Campbell, which seeks to amend motion number 7783 in the name of Liz Smith on named persons be agreed to. Are we all agreed? Yes. Parliament is not agreed. We move to a vote. Members should cast their votes now. The result of the vote on amendment number 7783.2 in the name of Aileen Campbell is as follows. Yes, 71. No, 14. There were 29 abstentions. The amendment is therefore agreed to and the amendment in the name of Jane Baxter falls. The next question is that motion number 7783 in the name of Liz Smith on named persons as amended be agreed to. Are we all agreed? Yes. The Parliament is not agreed. We move to a vote. Members should cast their votes now. The result of the vote on motion number 7783 in the name of Liz Smith as amended is as follows. Yes, 72. No, 19. There were 24 abstentions. The motion as amended is therefore agreed to. That concludes decision time. We now move to members' business. Members who leave the chamber should do so quickly and quietly.